Commercial Division, original side. Item number 2 with 3 for judgment, Messrs. Power Make Projects versus Messrs. Bharat Heavy Electricals.
This court is persuaded in view of the above reasons
to allow the prayer in both the applications for appointment of a sole arbitrator. The prayer made on behalf of the petitioner for appointment of one arbitrator for deciding the disputes in both the applications is found to
to be reasonable, since the earlier arbitrator's mandate appointed in AP 444 of 2023 was terminated by the order of the Learned Commercial Court at Rajarhat on 26/9/2022. Admittedly, the disputes between the parties arise out of the same contract documents, hence appointing two arbitrators for the same dispute between the same two parties may result in conflicting decisions apart from wastage of resources. This can easily be avoided if a single arbitrator is appointed to decide the claims in both the applications. AB 444 and 449 of 2023 are accordingly disposed of by appointing blank to act as a learned arbitrator for resolving disputes, etc. Urgent Forester certified copy.
Item number 4, Union of India versus Raitani Engineering.
In this matter, your lordship has
Microphone, please.
your lordship had passed an order on 28 August 2023. My lord, may I hand up the copy of the order, my lord? My lord, here, my lord, at page C2, my lord.
Did you give notice to your other side?
Yes, my lord, I had. At page 2, my lord.
Just show me the notice, please.
Notice of in the political case mentioned.
You're appearing for?
I am the petitioner, my lord. This is 36-2 application.
You are appearing for?
I'm the respondent. In the
You are the award holder?
Yes, madam.
Yes. That's all right. He's here. Yes.
My lord, here, my lord. In my lord, section 36-2 application, my lord, for stay of the my lord award, my lord, that application was made, my lord, and there your lordship directed that 3.43 should be deposited with the registrar original side, my lord, by the my lord petitioner.
Yes.
And that therefore, my lord, it 50% to be deposited by the bank guarantee and 50% in cash. My lord, here the railway is saying, my lord, the railway will deposit the entire amount by cash.
By cash.
By cash.
What do you have to say?
I have no objection. Your lordship may direct the
Windfall. Not a windfall. Yes. That's the only modification you want.
Only modification, no, that direction will deposit is to be made by 29th of November 2023. Still the time has not expired.
29 November.
Yes.
Have I mentioned that date?
Yes, that date is not the last paragraph, page 2.
yes, 29. The lordship may consider my lord, directing for the money to be kept in a fixed deposit because the interest is running. So my lord, the interest would accumulate there and the money which they deposit. Yes, the award data prays for modification of an order passed by this court on 28 August 2023 in an application by the award data for stay of an award dated 12 February 2016. Stop. The application was AP 467 of 2022, being the said application was disposed of by directing the award debtor to furnish security of rupees 3.43 crores within 29th November 2023. Stop. The award debtor was to furnish half of this amount by way of cash and the remaining by way of a bank guarantee, both of which were to be furnished before the registrar original side of this court. Stop. Next, learned counsel appearing for the award debtor seeks modification of this order to the extent that the award debtor will deposit the entire amount of rupees 3.43 crores
In cash. on the same terms with the registrar original side of this court within the time directed, that is by 29th November 2023. Stop. Next, the respondent award holder is present, is represented. Next, the order dated 28th August 2023 is modified to the extent of permitting the award holder to deposit the amount of rupees 3.43 crores in cash with the registrar original side within 29th November 2023, failing which the award holder will be at liberty to execute the award on and from 30th November 2023. Stop. Next, the registrar original side will keep this amount invested in an interest-bearing account in a scheduled bank. Stop.
Grateful.
I'm grateful.
Five, Mr. Sri Ganesh Engineering.
Mr. Tushar Kanti, they appointed.
I can't understand what, sorry.
Tushar Kanti, they appointed as a valuer. He's not available in Calcutta now. He's not.
And he's returning later.
But
Sorry, he's
after 1 month, he returned.
after 1 month,
He returned from Lucknow to Calcutta.
he returned. What do you mean? He's already returned.
No. He's now Lucknow, and after month, he's returned to.
Say that he will return after a month. Yes, RK Achivali. Very well. Learned counsel appearing for the petitioner. Praise for appointment of another valuer in place and stead of Mr. Tushar Kanti De, who was appointed as the valuer to visit the site in question and make an inventory of the material lying at site by an order dated 11th October 2023. Stop. Council submits that the appointed valuer is presently out of Kolkata and will return to the city only after 1 month. Stop. Next. Mr. Blank is hence appointed as the valuer to carry out the directions in the order dated 11th October 2023 in place and stead of Mr. Tushar Kanti De. Stop. The other parts of the order dated 11th October 2023 will remain unchanged. Next.
Item number 6, Hindustan Aegis LPG Limited. Filing of the note, file it by 1, please. The note has gone into 7 pages. I'm reducing it, Maharaj.
Yes, that's all right. But don't reduce it to an unreadable
No.
font, please.
No.
Yes, I will keep it at 1 o'clock then.
Please.
1
Great.
o'clock.
Great.
And ask Mr. Bose to be here, please.
My lord.
Great. Seven, proactive ship management.
My application.
Mr. Banerjee, you're appearing for who?
But the defendant over here, it's an application for.
I can't hear you, sorry.
It's an application for vacating of the
Of the order?
order of arrest.
Which order is this?
13th October.
No, have you annexed it?
Yes,
No,
but
this
I
is
made
the admiralty suit. Have you filed an application?
Yes, I have made a vacating application. Page 22 is the
22 of the?
vacating application.
That is what, I don't have it with me. AS6, 8. G2. Yes, 26.
Page 22.
Yes. You're for the owners?
Yes, for present owners.
Yes. Yes, Mr. Banerjee.
Your Lordship was pleased to grant an order of arrest of the particular vessel. The admitted position is that today he was supposed to have rendered technical management services to the erstwhile owner.
Yes.
This is his admitted case. He did it to the erstwhile owner. The agreement between him and the erstwhile owner of the vessel specifically provided that his services will come to an end immediately on the vessel being sold to a third party, if ever. Next thing that I say is,
You're not the third party. You're the present owner.
I'm the present owner.
Yes.
I'm the present owner. So I don't have any agreement with the thing. It was with the previous owner. My most important point that I would like to urge before Lordship is that he might have a maritime claim, but he doesn't have a maritime lien.
Yes.
Maritime claim, lien is there in every maritime claim. But every maritime claim doesn't have a maritime lien. So his claim, whatever, is against the previous owner. It is not, a lien travels with the vessel, but a claim doesn't. His own case in the plaint is that it is a maritime claim under section 4. And he was seeking arrest under section 5. If my lord kindly takes the plaint.
Affidavit of arrest is here, Mr. Banerjee. The affidavit of arrest is here.
Yes. In the affidavit, it's there.
বইটা লাগবে 27 Yes, Mr. Banerjee?
May I hand over a copy of the plaint to your lordship?
Yes.
If my lord kindly comes to page 10, lord, paragraph 19 of the plaint,
Page 10.
page 10, paragraph 19.
Yes.
May I place it, my lord? The plaintiff has a valid maritime claim against the vessel. The plaintiff is entitled to move against the defendant vessel and GOS Spielman, which is my client, for the same. The plaintiff's claim is a maritime claim as per provision laid down in the Admiralty Jurisdiction Settlement Act 2017 as well as the laws prevailing. The plaintiff's claim is a maritime claim falling within the scope and ambit of section 4 and section 5 of the Admiralty Jurisdiction Admiralty and Settlement of Maritime Claims Act 2017. The plaintiff is entitled to move the arrest and blah blah blah. So it is his own case that he comes under section 4. As far as a maritime claim is concerned,
I have a book. Which
your lordship has,
Yes.
yes, no, section 4.
Section 4. Yes. Yes.
The High Court may exercise jurisdiction to hear. Your lordship has got section.
Yes.
4? The High Court may exercise jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of any, then is L, my lord, if your lordship comes to
L.
L. So
Is
I am,
that says management and all that?
yes.
Yes.
So my lord, I am not, so therefore he himself says he comes under section 4. I am also not disputing the fact that he comes under section or whatever his claim may be. My point is, my lord, it may be a maritime claim, but not a maritime lien. His own case that he comes under section 4. Maritime lien does not come under section 4. As your lordship knows better than me, my lord, that it comes under section 9 of the. Now, as far as this is concerned, my lord,
Yes.
my learned friend could very well have moved an arrest if I had been the owner of the vessel at the time of the claim. My humble submission is, for a maritime claim, you have to move against a person against whom I have a claim, and he continues to be an owner on the date of arrest.
So you're saying privity is essential for that?
Yes, that's it.
Yes. But Mr. Banerjee, subject to what you show me, I think some documents were shown to show that there was continuity in terms of payment for the services rendered,
No, I was never was any
as in payments made by you.
was any document shown to your lordship that I was liable to make payment? If those payments were made on behalf of somebody else, is a different thing. But I was liable, I had any obligation to make payment of anything? Because today, as on this day, I specifically state that the agreement with the plaintiff came to an end immediately after the sale of the vessel. That is as per
And the contract provides for that?
yes, that the contract specifically provides that. I shall come to it. If you can contact about it. My lord kindly comes to the bingo.
So you're saying that the plaintiff comes within 4 but not 9?
That's he himself says he comes on the 4. So the lien does not continue. If the lien does not continue, that he cannot if there is no lien, then he can't arrest the vessel. That is my short point, your lordship. He may have a claim, good, bad, I'm not getting into against the owner, but it will not carry on with the vessel.
Yes. The vessel is arrested now in.
Now I'll show to you.
Has it sailed off from Port Blair or still Port Blair?
I'll now some interesting things I'll show to your lordship.
No, first the contract, please.
Oh, contract. Yes, my Bimco, may I just. No, 40. Picking application. That's at 27. The agreement starts from page 27.
You're referring to the plaint.
No, my vacating application.
(27)?
Yes.
Yes. This is the agreement between the plaintiff and the.
Plaintiff and the
Erstwhile.
erstwhile owner.
How do I know that?
Your lordship fine. Meenakshi. No. Owners. Yes. Registered office, Meenakshi Fishing. Lordship sees in the top column, owners and name. Just below Mumbai, India is written.
Yes.
Lordship found Meenakshi.
Yes.
They are the erstwhile owners. This is the agreement. Now, my lord, if your lordship comes to page 39.
And proactive is
Proactive is my lord friend.
plaintiff.
Plaintiff.
Yes.
Now, your lordship will come to page 39.
Yes. Yes, Mr. Banerjee.
My lord, I'm sorry, my lord, I should show one thing More to your lordship in the first page, at page 27. My lord, if my lord kindly comes towards the lower portion of that particular page, my lord,
Yes.
your lordship finds, my lord, block 18. My lord, your lordship find 36 months,
Where? Page 37,
no, page 27, this is
27. Yes, yes,
page 27.
yes,
If your lordship, towards the lower half of the page, my lord, 18, my lord, minimum contract and state number, so and so. Then next 36 months and continuing unless terminated. Lordship has found that?
no, where is it?
And on the left hand side of the page,
Yes, yes,
36 months, continue unless terminated.
yes,
Lordship fine. And the date of agreement is 1st of January 2017.
yes,
Now your lordship should kindly come to page 39.
yes,
Your lordship will come to clause 22 C.
yes.
Clause 22 my lord, deals, I'm sorry, page
C.
39.
C, yes,
Yes, my lord, 22 C. Lord, termination various clauses on top. Then next is this agreement shall be deemed to be terminated in the case of sale of the vessel.
yes,
If the totally, my lord, that is not it. So my lord, it is specifically provided
yes.
that on the sale taking place.
Termination with sale. Yes,
Yes. So deemed termination. Now, would your lordship kindly take their affidavit of arrest once? They are moving.
yes, Mr. Banerjee, hurry up.
Yes, ma'am, I'm sorry. Uh, Page 21. Yes, this certificate of registration, my lord, it is at page 21 of the affidavit as said.
21,
Yes, ma'am. They are aware of this particular document. Yes. Page 22, if my lord kindly comes to, that is where my name is.
What is this? Page 22.
22, my lord, you'll have to find my name.
No, that I have. But where do you come into the picture? From?
No.
What is this document?
No, this is the certificate of the Indian registry.
Yes,
This is the
yes.
registration.
The one which was shown as to get around that exception.
So now I am the owner. Look, this is as on this date, I become the owner. I am the
This
vessel.
dated when?
1st April
1st April of which year?
2021. Look, just above the seal on page 22, you'll have to find. The registration is on the first page. Not to find. So that is it. So they're fully aware of the fact that I am now the registered. Now, my lord, your lordship kindly take the affidavit of asset arrest once. Because they are moving ex parte with great urgency. My lord will kindly come to page 18.
Yes.
My lord will kindly come to page paragraph 48 first.
yes,
Type of ship, admittedly, there is no dispute as far as this is concerned. passenger vessel. Now, paragraph 49 is their urgency paragraph. The respondent vessel is on her way to Port Blair. The vessel is expected to sail away
This
from.
must be a typographical error, is it?
There's no
11
other
February
pleading.
2018.
There's no other pleading in this entire thing. For urgency to move this arrest, there is nothing else. And my lord, what is something? Now, my lord, may I just say this? Today they found great urgency. As I said, my lord, they were fully aware of these that we have become the owner because there was another round of litigation,
2 rounds.
2 rounds.
One was
and-
withdrawn, the
yes.
second one was withdrawn. The first one was unsuccessful.
So they are, that's how dismissed for default 1 round and whatever it is, yeah, earlier round. And what was their urgency in the earlier rounds? My lord will kindly come to. If my lord takes my vacating applications, second volume.
Yes.
Page 141.
Yes.
This is an order passed by this honorable court on 18th of July.
Yes.
I won't wish to lecture with the entire order, my lord. Last paragraph, it is fairly submitted.
Yes.
Fairly submitted by the parties that there is no scope of passing any ad interim order at this stage for the proceedings. Liberty is granted to the defendants who filed in the department. So 18th of July 2022, there was no urgency in the earlier round of litigation.
This is the first or the second one?
This is the second one.
Second.
Thereafter, the suit was withdrawn in the month of December. After that, there was no urgency. Then this suit is now filed after 10 months. There is no pleading in the entire arrest application that what is the urgency which has cropped up now. The only thing that is said over here is 2018. My humble submission is number 1, the arrest is not maintainable because there is no lien. The lien does not.
Mr. Banerjee, doesn't section 9 of the 2017 Act talk about, it talks about priority in lien, those who claim lien or something.
So he's not claiming under the lien under section 9. What is provided in section 9? He's saying not all maritime claims would have there be a maritime lien.
So you're saying lien is a subset of a claim?
Yes. Lien is a subset. Because not all, the bigger set is the claim, the smaller set is the, because not all of them, those, my humble submission is his case, he comes under maritime claim, I'm no doubt on that. Without admitting the claims and everything else, but today it doesn't carry on with the vessel. Point number 1. And I would like to cite.
And Mr. Banerjee, if that is correct, then are you disputing that you made payments to the plaintiff even after termination of the
It
contract?
was not my obligation. It was the plaintiff, the previous owners. Some obligations I discharged for them, for their behalf. Because there was no contract, privity of contract with me ever. Today the agreement.
So that was part of a contract between, understanding between you and the erstwhile owners?
Yeah, on his behalf, I may have made some payment. But today I had no obligation as such to make any payment to them because there is no agreement as on this date between them and my clients. Number 1. And he's not pleaded that also in any case. The payments, if any, is due from the previous owner. That is his, and he's saying section 4 maritime claim and may I
And what about the previous owner? Sailed away as well?
They're there.
Previous owner, is around.
They're there. It must be there. That's for them. My lord. I have no connection with the previous owner per se. I have bought the vessel now. So it would be a claim in personam against the previous owner.
Yes.
Judgment টা দেখিয়ে দিন। কত পাতা है ना तो इसमें?
And Mr. Banerjee, what is it? What is the status of the vessel now?
The status of the vessel is even better. I'm grateful to your lordship. Today, the certificate of fitness has expired. The vessel cannot in any case move. Now, I am going to, why he has come, I'll tell you, because now I will be applying. As of now, there is
Applying for what?
for getting the
Renewing the certificates of
As of
fitness.
now, I have not been able to get the certificate. Now they don't want me to get the certificate of it. That is the main thing. That I put this pressure so that I don't get the certificate. But may I just show you, lordship, the certificate of fitness once?
How will they gain anyway if you don't get it?
It is pressure.
Mr. Banerjee, hurry up and make your submissions.
Yes, Lord. May I just quickly, Lord, come to lordship, kindly come to second volume once of my vacating application, place 147. That is the certificate of fitness. Page 148 is certificate.
Yes, so
thing.
how does it take your case forward?
It is that today, in any case, I could not have moved it. Because the certificate of fitness of the vessel is not there. Nobody will allow me to move this unfit vehicle.
Very well. So you're saying that the vessel would not have sailed away from Port Blair?
Nowhere. Because Fellowship sees page 148 1. The certificate, unless previously cancelled or suspended, remains in force till 24th July 2023.
Where are you seeing all this?
Page 148, your lordship is seeing.
Yes.
Towards the bottom, this last paragraph, my lord, on the middle of the page, this certificate, unless previously cancelled or suspended, remains in force till 24th. So I could not have even.
No, where are you getting that date? This
when,
certificate?
This certificate, unless previously cancelled or suspended.
This is page 148.
148. My lord, after the block, my lord, then second paragraph, my lord, after that, this certificate, unless previously cancelled.
Yes.
Your lordship has got that paragraph? Or suspended, remains in force till 24th July 2023. I don't even have certificate of fitness today. No, I can't get this certificate of fitness renewed if this is the arrested. Yes.
So you mean to say that the vessel has been in Port Blair up from 25th July 2023? Stranded there.
It can't go anywhere else. It's a passenger vessel. I'll tell you, this is the main season during the monsoons where these vessels don't move.
Yes.
These vessels do not move when during the monsoon period. It is post-monsoon, my lord, that is when the vessels move again. Because of tourists and everything else. So now is the time again they get their certificates renewed and certificate of fitness so that I don't get this.
Yes, but how will they gain? That's my question to
Just
you.
put a pressure on me. Because tomorrow, once I get the certificate of fitness, then I can fly commercially. So not a question of running away anywhere. But because I.
Very well. Your next point.
Yes, sir. Now you'll have to. But I would like to rely on a judgment, my lord. My lunch friend himself appeared.
Microphone, please.
2018, volume 16, SEC, page 117.
Yes.
What is it? Paragraph 19, my lord, will kindly come.
What is the point?
My lord, that today he cannot, my lord, if there's a new owner on the basis of a maritime claim, he cannot arrest the vessel. He has to have a lien, not a mere claim.
Yes.
Lien travels with the vessel, but a claim doesn't travel with the vessel. Without troubling your lordship, as your lordship will waste your lordship's time. But if my lord kindly comes to
Yes,
page 138, when I to the middle of the, that's why I'm not with,
yes,
Lord, suffice to say, but my lord, if my lord
Yes.
kindly comes to, suffice to say that clause K of Article 1 states that important materials, whatever supplied to vessels for a maintenance and
Article 1 clause A is that particular contract between the parties before the Supreme
No, no,
Court.
no. This is the Brussels Convention it's referring to.
So say that, Mr. Banerjee. Yes,
Important materials, whatever supplied to a ship for her operation and maintenance would fall within the jurisdiction of maritime lien. A maritime lien, on the other hand, attaches to the property of the vessel whenever the cause of action arises and travels with the vessel and subsists whenever and wherever the action may be commenced. Now, your lordship kindly come to paragraph 24.
Mr. Banerjee, I may not have any issues with this proposition. I cannot. What you have to show is that the plaintiff did not have a maritime claim or a maritime lien, but had a maritime claim, but
own case.
only having but you have to show it in the law. In law.
Sorry, I didn't get you.
Very well, you please make your submissions.
No, because my thing is that his own case is that he has a maritime claim under section 4.
You have to show, Mr. Banerjee, that because he does not have a maritime lien, therefore he could not have got that order of arrest. That is that's
Okay, fine. So it does have the personal, it doesn't come under section 9 of the lien of the priority in the state over there. Yes, but you have to show that to the court.
Lord, if your lordship comes to section 4,
Yes,
L,
I've seen 4L. That's services.
so it comes over there
Yes.
in 4L.
Yes, now I will not would kindly come to 9. Yes. The other priority of the maritime claims. Lien. Okay. That every maritime lien shall have the following order with A is one claim for wages and other sums due to the master sponsor. Next, claim in respect of loss of life. Personally, which one are you coming under? I don't cover manager this. I don't come under before the vacation. I don't come under 9. What I'm trying to say, yes, but you have to show it. Therefore, we have to pay in none of the I saying this claim comes under 4, which is a maritime claim. I do not come under the claims of model with that fact. That is the basis of the order of arrest. You will have to show that the order of arrest is to be vacated because in law, and you have to show from the law that despite having a maritime claim, he does not have a maritime lien, and despite having a maritime claim and because he does not have a maritime lien, therefore the order of arrest must go. That is to call before which does not, I say this, Supreme Court doesn't help him at all. It just says lien travels, maritime lien. The paragraph 24 does, and I would have come out to place paragraph 24. But today, Milord, he does not have. He does not have any of the characters as required in section
9. So he does not have
That's
a
your submission. You have to show it.
Lord, if your lordship kindly takes 9, Lord, line what all comes under 9. Well, I cannot show the negative. Lord. Today, his own case is 4. Lord, none of the things as provided in section 9 are there as part of his claim or reasons for his claim. Lord. The first one is claim for wages. Next, your lordship has found is loss of life or personal injury incurring. Lord, or that one. Next is reward for salvages services, including special compensation relating to thereto. Next, claim for port, canal, and others. Then claim based on
Yes, but show me something which says that if you don't have a maritime lien, you cannot get
Yes,
an
that
order
is
of
there.
arrest.
Supreme Court says that.
Mr. Banerjee, if you want, I can give the matter tomorrow. You can get ready.
Just take 1 minute.
Because you have to keep up with the pace of the court. I'm sorry to say that.
If my lord kindly comes to paragraph 26. Article 8 of the state states that the character of the lien, your lordship is, sorry.
Yes.
It is thus clear that a claim for necessary supply to the vessel do not come to a maritime lien attached to the vessel.
Mr. Banerjee, come back tomorrow. I'm sorry.
You lordship just,
No. Every day I have about 3-4 judgments to give. I just cannot handle this pressure.
if my lord.
And you have to keep up with the pace of the court. Sorry.
My lord,
Yes.
my lord kindly comes to paragraph 28 once.
No, come back tomorrow. You cannot be searching for your points. Come back ready and in 5 minutes. That's the way I like
One
it.
thing in paragraph 28 is all I have to cite. Your lordship.
But I am not clear on the law, Mr. Banerjee. I cannot vacate an order unless I am clear on the law. No matter what the Supreme Court says, I have to understand the law. That is how it should be in all circumstances. Tell me tomorrow. Tomorrow or day after?
Tomorrow.
Yes. The owners have filed an application for vacating an order passed by this court on 13th October 2023. Which was an order of arrest of the vessel, which was docked at Port Blair, docked in Port Blair at the on that date. Stop. Next, the argument for vacating that order of arrest, the order of arrest, is based on the fact that the plaintiff, despite having a maritime claim under Section 4 of the 2017 Act, did not have a maritime lien against the present owners. Stop. The argument is also that the present owners are not liable for any claim of the plaintiff under the 2017 Act. Stop. Learned Counsel opinion for the owners has also argued that the plaintiffs did not have any urgency to move the affidavit of arrest, to move the suit, the admiralty suit. As on 13th October 2023. Stop. Next, list this matter tomorrow. Mr. Banerjee, I'm telling you what you have to establish. That the plaintiff may have a claim, a maritime claim, but does not have a maritime lien. The plaintiff on facts would not come under Section 9. And if the plaintiff does not come under Section 9, then the order of arrest must go, because the order of arrest was made or was passed only on the presumption of, only on the grounding of Section 4, not on Section 9. If Section 9 does not come into play, or if the plaintiff cannot establish a case under Section 9, then the order of arrest must go. All right, that's a simple point. I have noted your argument on the urgency and on the contract and everything, but on the on the law, Supreme Court doesn't help you. Supreme Court just says lien travels with the vessel, but you have to show it on the facts. Yes.
Item number 9, Mrs. Greta Engineering.
Well, this is my application for appointment of an arbitrator under
Just
section.
microphone, please.
Well, this is my application for appointment of an arbitrator under section 11 of the Arbitration and Conciliation Act. Well, the arguments are complete. Well, we have also submitted the list of dates before your lordship.
Yes. I will dictate the order at 12:15.
Ten, Mahendra Shiblal Gandhi.
That we had moved an application under section 11. Your lordship was pleased to pass it on.
Yes,
But appointing an arbitrator. But this is an application seeking all of them. I tell you.
recall, why have you, where is your other sir, Mr. God?
But I have, on the last occasion also, they did not appear. We have served them, but this is the affidavit of service. And Lord, this morning, Lord, we found out that even the Kharagpur has been served.
This morning,
Yes.
but that's not right if I take up this application. And what about the other Kharagpur,
Others-
and where is the other office?
Calcutta office,
Calcutta has been served when?
well, 14th of October.
14th October
Yes.
on Saturday.
Yes, and Kharagpur was served yesterday, but it was uploaded today.
So you were the respondent in the
No,
application?
we were the petitioner. Lord. We were the petitioner. Lord, your lordship's order is at page 26.
So you got the order for appointment?
Yes, Lord, your lordship's directed, Lord.
Yes, what is the change? Recall you
Lord,
want?
only thing is that, Lord, the
Arbitrator?
arbitrator, Lord, is stationed in Delhi,
Very well. You want somebody in Calcutta?
Because, Lord, the
Man or woman?
Lord, anybody of your lordship's choice. I have no objection. Page 29, if your lordships looks at this, the current balance sheet, Lord, this is the net profit that the business has. About 4 partners. So they earn about 12 lakhs, Lord.
So you're saying somebody less expensive?
No, expense, I am not saying, Lord, I'm only saying somebody in Calcutta so that, Lord.
The
cost-
travel and all that?
Yes, cost effective, it becomes cost effective.
Very well. Learned counsel appearing for the petitioner, applicant, who seeks modification recalling of an order passed by this court on 25th September 2023, appointing a learned arbitrator
Praise C, Lord, your lordship.
for deciding the disputes and differences between the parties, comma, submits that the petitioner prays for appointment of an arbitrator who is based in Kolkata. Stop. Next, it should be clarified that the erstwhile arbitrator, that the erstwhile appointment was of a retired judge of the Delhi High Court. Stop. Counsel submits that given the petitioner's consolidated income, comma, the parties would be comfortable with an arbitrator who is based in Kolkata. Stop. Next. Have you already communicated the earlier order to them? No.
We have.
So you took, what about 11, 12 days to decide?
Lord, I tell your lordship, very frankly, the client.
Not 11, 12 days, about more than 2 weeks.
Lord, the client's reaction was immediate, but Lord, the learned advocate on record was little hesitant.
Very well. Next, GA 1 of 2023 is accordingly allowed and disposed of by appointing blank in place and stead of the erstwhile appointment. Stop. The court is informed that the petitioner, that the order dated 25th September 2023 was not communicated to the erstwhile arbitrator.
Pachok.
What was the claim, Mr.?
Lord, there are 4 partners. Lord, the petitioner's claim would be about to the tune of 2 crores. And Lord, the earning net profit I found, Lord, from the balance sheet, it comes to about 49-50 lakhs per year.
So, total would be what, about 3 crores? About 2.5,
2.5 maximum.
2.5.
Maximum.
Yes, the appointment is to be communicated to the newly appointed arbitrator by 19th October 2023.
Eleven, Victoria Construction Limited.
Respondent, my lord,
Microphone, please.
for the respondent, my lord.
Yes, you want to take
Morning,
instruction?
I have been served with an email. from
Microphone,
my client.
please.
I'll indicate, my section 11 application, he had said there were terms of settlement that was
Yes, yes.
exchanged. I had said there were no instructions. Yesterday, they've given us better instruction. But we will not record the talks of settlement are on, but keep it after the vacation. We'll come back and trouble you.
Very well. List this matter on, give me a date, please, both of you. Mr.
Immediate on reopening the
Gangopadhyay? You are Mr. Gangopadhyay?
Somnath Gangopadhyay.
Yes, give me a
I have
date.
filed the
please.
Vokalatnama.
Give me a date.
20th.
Mr. Gangopadhyay, give me a date.
My lord, I'm giving it to my lord.
November.
Which one did you say? 20th?
20th.
List this matter on 20th November 2023 as prayed for. Stop. The respondent has filed the Wakalatnama as directed yesterday.
On 30th, last Friday.
Very well. The respondent has already filed the Wakalatnama.
Great.
ওটা his করে his.
Item number 12, Mohammed Nafiz Uddin.
My lord, my application under section 11.
I'm
My lord.
opposing, my lord, this application.
Yes.
Yes. My lord, there was a letter of intent that was issued by the respondent on 22nd of July 2019.
Yes.
Now, in terms of the agreement of 20th July, 22nd July, my lord, I was required to supply and my lord, deliver acid-proof bricks. And my lord, the delivery is at a place at the site office of Ramagundam Fertilizers Chemical Limited at Telangana.
That
Lord,
is the
lordships.
agreement between the
Yes.
parties.
Yes, kindly see.
Sorry, just show me the page number, please.
At page 11, the agreement starts.
Yes.
My lord, if lordship would kindly come to page 12, the site where I am required to deliver the goods have been mentioned. Page 12, clause 5.
Yes.
My lord, that's
Page 12, clause 5.
yes,
But
page 12 of the application.
yes, clause 5. Yes.
Yes. My lord, care of Ramagundam Fertilizers Chemical Limited. See HX Road near Gautam Nagarwan. That's the address, my lord.
No, so what are you trying to show?
Yes, ma'am. This is the address where I'm required to deliver and supply the goods. Now, my lord, if
So
lordship.
what goods, you're the supplier of what,
Yes.
what kind of goods?
But this is acid-proof bricks. But this is a special type of bricks where it is, which is made or manufactured for the purpose of being resistive to any corrosive liquid or corrosive material.
Very well. So show me the first page of the, what is this, a work order? What is it?
Yes, it's a, one of the work order.
And the arbitration clause is where?
Yes, clause, page 15, clause N,
Page 15.
page 15 of the petition.
Clause N.
Yes,
Yes.
yes, my lord. It says that second line, my lord, if we fail to settle the differences or dispute arising out of it in
So
connection.
the arbitration clause is in the work order?
Yes, my lord, it is there in the work order. And this is the only work order that was issued to us.
Yes.
And my lord, it says venue of the arbitration shall be Kolkata, since my lord, there is no contrary indicia. My lord, the venue in this case will be regarded as the seat of arbitration.
Section 11 hardly matters.
Yes, now my lord, between 26th of June 2019 to 26th of September 2021,
26 June 2019.
19 to my lord, 26th of May 2021, my lord, we issued invoices on account of works done in terms of the contract. My lord, the aggregate amount of invoices was 83.50 lakhs. Now, my lord, we requested them to make payment. My lord, they did not make payment. Instead, their employer, the Ramagundam Fertilizers Chemicals
So
Limited.
you're the subcontractor.
Yes.
Say that, why aren't you saying that I'm the subcontractor? Because one of the respondent's employer is Ramagundam Fertilizers Chemicals Limited. One of they directed, but they directly made payment to me to the extent of 68.28 lakhs. Now, my lord, after giving adjustment of that 68.28 lakhs, my lord, the sum that is due and payable by them as of my lord, on and from 22nd of December 2021 is 11.30 lakhs along with interest, which aggregates
To a sum of rupees 15.30 lakhs.
Yes.
Yes, my lord, from page 46 onwards, my lord, I have enclosed the demand notices. Page 46 onwards, my lord, the first demand notice that I issue is dated, my lord, 22nd of December 2021.
46.
Page 46.
22nd.
My lord, 22nd of December 2021, page 46.
Yes. Yes.
Yes, we have requested for release of 11.30 lakhs. My lord, this was followed by subsequent demand notices. Now, my lord, lordship would kindly see, my lord, my section 21 notice along with my request to the respondent.
So how many demand notices did you give them?
My lord, 3 to 4, my lord.
3 to 4.
The last is, my lord, which is the section 21 notice, which is also a notice under section 11 subsection 5. My lord, I have nominated my arbitrator. My lord, they have not agreed. Hence, my lord, I have come before your lordship.
Give me the page.
Yes, lordship would kindly see, my lord, page 57, the letter starts. Page 57, this is 28th of August 2023. My lord, this letter was received on 30th of August 2023. My lord,
Yes.
kindly takes, my lord, page 61, paragraph 17 of the letter.
61.
Page 61.
Yes.
Yes, my lord, we have set out the arbitration clause which is there in the work order. Now, lordship would kindly takes the next page, page 62.
No, you have mentioned 2 letters of intent at
Yes.
paragraph 17.
Yes, one of the first one was a proposal, my lord, which was not acted upon. The
Yes.
final contract between the parties is 22nd July 2019, which contains the arbitration clause.
So 22nd February doesn't have an arbitration
It
clause.
does not have any arbitration.
Yes.
Now, lordship would kindly take, my lord, page 62, paragraph 19.
Yes.
My lord, we appoint our arbitrator and we request them to agree.
They
However,
will, they haven't replied.
no, no, they have not replied.
Yes, Mr. Banerjee.
My submissions are mainly, my lord, twofold, my lord. My lord, I'll start from, my lord, where my learned friend ended, my lord. Your lordship had pointed out that there are 2 letters of intent, my lord, which are mentioned, my lord. However, my lord, my learned friend says that the first one was not acted upon. It was never acted upon, and it is only the second one.
No, Mr. Basu said that the second one has the arbitration.
Yes, and the
clause.
first one was only a proposal and it was never acted upon. The
Yes.
first one. My lord, I'll place, my lord, page 46 onwards, which are the demand notices, my lord. Your lordship will kindly have a look at page 46 onwards.
So what are you saying? That they can't make a consolidated demand?
No, my claim is, my lord, they have in fact raised bills. Their demand notices refer to the first letter of intent. Their invoices are raised based on the first letter of intent. And whatever disputes they have are based on the first letter of intent, my lord. And my lord, the claims, if any, my lord, arises out of the first letter of intent, and it does not contain an arbitration clause, my lord, and this honorable court does not have jurisdiction to entertain, my lord. They have intentionally not annexed, my lord, the first letter of intent. However, my lord, if your lordship kindly takes a look at the invoices which have been raised by them,
all, my lord, refer to the first letter of intent of 22nd February 2019 and does not mention any details of the second invoice, which my learned friend says of July 2019, my lord. I'll take your lordship through the documents, my lord. Before that, my lord, your lordship will kindly have a look at page 46 once.
Yes.
My lord, your lordship will kindly have a look. There's a reference, my lord. Reference to 02 PR ends with 101708 dated 22 February 2019.
Page 46.
Page 46, my lord. At the
Yes.
top reference, this is, my lord, the LOI. My lord, LOI number is dated 22nd February 2019. Subject is letter for release of payment, my lord.
Yes.
Similarly, my lord, page 47 also contains the same LOI number, my lord, which is reminder letter for release of payment, which is of 22nd February 2019, 101708 dated 22nd February 2019. And all of these documents till page 50, which are the demand notices, are of the letter of intent dated 22nd February 2019. And if your lordship will also kindly take the invoices once, my lord, the invoices are from page 19 onwards, my lord. The invoices also, my lord, refer to, my lord, kindly have a look at page 20 once. My lord, at the top, my lord, left corner, there is an AL number, reference number. Page 20 at the top is AL number, reference number. It's 02 PR 003 volume 1101708. The same one which is there in the demand notice, my lord, of 22nd February 2019.
Where are you looking?
My lord, on the left, my lord, there is invoice number 2.
Yes, AL.
AL number reference. This is what the number, my lord, 02 PR SUP 003 volume 11 101708. This is the same number, my lord, I pointed out in page 46 onwards, my lord. So, my lord, the letter of intent of 22nd February, which did not contain an arbitration clause, was in fact acted upon. Invoices were raised, demand notices were raised. However, my lord, today, my lord, a second letter of intent, my lord, which contains an arbitration agreement, has been annexed to this application only to invoke arbitration and give jurisdiction to this honorable court. However, my lord, the disputes which arises out of the LOI dated 22nd February 2019, if any, has to be before a court of civil jurisdiction and not an arbitration court, an arbitration tribunal, my lord, because that does not contain an arbitration agreement, and they have, my lord, intentionally not annexed that LOI of 22nd February 2019.
The one which has been referred to in the section 21 notice.
Yes, it's not there, my lord. They've only annexed a LOI of 22nd July 2019, and there's no invoices which relate to that. There's no demand notices which relate to that, my lord.
So all the demand notices relate to which one?
Relate to the LOI of 22nd February 2019, my lord. I'll take your lordship through each and every
And
document.
which one have they not annexed? The annex, the 22nd February 2019.
Yes, which does not contain an arbitration clause.
Yes. So you're saying that they can't make a consolidated demand.
Well, they did not have a demand with regard to 22nd July 2019 ever, my lord. There's no document annexed. Kindly have a look at 46 to 50 onwards, my lord. All the demand notices only mentions one LOI of 22nd February 2019. And as far as, my lord, the demand notice of, as far as the LOI of 22nd July 2019 is concerned, I have instructions from my client, and if your lordship permits, my lord, I'll file by affidavit, my lord. All payments which were due and payable in terms of that LOI have been paid, my lord. No disputes with regard to that. There's no arbitrable disputes.
Very well. Yes, Mr. Basu.
Yes, my lord, kindly takes, my lord, my demand notice, which is of 22nd August 2023, page 51. My lord, the 22nd February 2019, my lord, which was the work order that was further amended by the work order of 22nd July 2019. My lord, that is the reason why I am invoking the latter one. Kindly see, my lord, page 59, my lord, paragraph.
No, you said 51.
Yes, page 51, my lord, paragraph 2. In fact, my lordship would kindly see from paragraph 1 onwards of page 51, the demand letter dated 22nd August 2023.
Yes.
My lord, pursuant to notices inviting tenders dated such and such, you had engaged my client for providing and laying acid-proof bricks as per your bill of quantities as per Annexure A. Now, my lord, kindly see the next paragraph. The work envisaged therein was granted in favor of my client by way of a letter of intent dated 22nd February 2019 and further amended letter of intent dated 22nd July 2019, which was issued to you. Now, my lord,
Yes.
if there are two work orders, and my lord, the first work
No,
order
these
is,
are letters of intent.
yes, two letters of intent. If the first letter of intent gets amended by the second letter of intent, which contains the arbitration clause, my lord, I will invoke the second one. Because, my lord, if it has amended the earlier terms, then, my lord, the subsequent one,
That
which
is
is,
fine, but where is this, how do I know that this 22nd February 2019 was amended by the second one, 22nd July 2019?
yes, my lord. Kindly see, my lord, page 11. Yes, because, my lord, 22nd July 2019, page 11 LOI, because this says that this is the final word order, final letter of intent. Kindly see the language, my lord. With reference to above and subsequent discussions we had with you at our Delhi office, we are pleased to place our LOI on you for providing laying acid-proof bricks as per enclosed BOQ technical specification annexed. Now, my lord, next. Your rate as furnished is the final rate for the item as BOQ drawing specification, inclusive of all types of tools, tackles, equipments, etc. The rate will remain firm and shall not be subject to any escalation for any reason whatsoever till completion of work as per scope. However, any statutory variation imposed by government shall be payable, refundable at actual. But this is the final letter of intent.
No, where does it refer to this 22nd February 2022?
But this does not refer,
2019?
but this does not refer to the 22nd February 2019, but this is the final document.
Mr. Basu, you have to show. If you're saying that it has been amended
Yes.
and 22nd July is the final work order, the letter of intent, you will have to show that. The documents here don't show that.
But I have, by way of inadvertence, the 22nd February 2019, is not a part of
You
the
can file a
record.
supplementary
Yes, Lord,
affidavit
should kindly give.
and come back after the holidays.
May I file an opposition to show that whatever payments were required to be
Yes,
made?
yes.
I'll-
Learned counsel appearing for the petitioner is given leave. No, the petitioner is given leave to file a supplementary affidavit to bring on record the first letter of intent dated 22nd February 2019, which learned counsel appearing for the petitioner says was amended and resulted in the final work order of 22nd July 2019. Stop. Next, the respondent will also have an opportunity to file its affidavit in opposition, which shall be done within,
2 weeks after vacation.
why? What will you do in the holidays?
Vacation,
Why?
but we are not.
No, everyone's working, you will also have to work. Yes, on 17th,
You're not.
on 17th November 2023, reply within,
1 week thereafter.
reply within 1st December 2023, stop list this matter on 4th December 2023.
Keep your
Great.
best.
Item number 13, Sheila Sen, another.
This is my application under section 11 of the Arbitration and Conciliation Act. Previously, below the section 9 application was filed. We are enjoying interim orders in appeal. The development agreement is dated.
You're enjoying interim orders in appeal means
It-
what? They went up in appeal.
No, we went up in appeal. And
Yes.
the development agreement is at page 9, 15th of December 2012. Lord, the arbitration agreement is at page 22. Capital A, my lord, is the typed copy. Clause 17.
Seventeen.
Yes, my
Yes.
lord. Clause 17 is the arbitration agreement.
What is what will you develop?
But they were supposed to develop, my lord.
Nine company for Senado. And but for 10 years, they didn't do anything. Ultimately, will not be discovered that the controlling mind of the developer decided not to develop the property and he refurbished it as his own house. He wanted to shift in, then told us you to sell the house to me, we refused and will not became.
So now this is the gory story. So we terminated the development agreement on 2nd of April 2023. Page 48, my lord, is the termination letter.
Yes.
We, my lord, wrote to port projects, the respondent, and cancellation of the development agreement and reference of disputes to
For
arbitration.
11 years, you were waiting for them to perform.
Yes, because there was a question of vacating.
And when did you find out that they've moved in instead?
Not around a year back, 6 months, my lord.
Yes.
And we've invoked arbitration. And Lord, this is in fact the letter. And page 56, my lord.
Is there 21 notice?
Yes,
And you straight on went with the 21. You did not give them any other letters
so, my lord, it was very,
from
very-
2012 to 2023.
there's really nothing much correspondence.
Where is the 21 notice? Page
My lord,
56.
page 48, my lord.
48 or 56?
My lord, 56, my lord.
56 can't be. 56 is the last page
Sir,
of
48, my lord, I'm sorry. wait, you need to put 48 at 56, my lord. Give me that.
and you invoke the arbitration clause where?
My lord, page 56.
Yes.
Please treat
No.
this as
You have appointed somebody. Where is? you
in
have
light
invoked-
of dispute, my client refers the same to arbitration, appoint such and such. And you are called upon to name an arbitrator of your choice, so that the two may appoint a presiding arbitrator.
How have you explained the interregnum, Mr. Chaudhary?
The interregnum, my lord, the refusal to perform, my lord, is within the period of 3 years.
So there must be something from their side or from your side.
Yes, when we discovered, my lord, that they, my lord, were not interested to develop the property and were acting in clear breach by converting the property into the residential house of their director. This discovery, my lord, is recent, which is why, my lord, we came to court.
No, no. How do you beat the, how have you explained the interregnum? Interregnum.
In paragraph 9, my lord, in fact, paragraph 8. We were supposed to vacate, my lord, these tenants. And we filed a suit for recovery of possession. Then, my lord, paragraph 9. This point number 1 was conducting the suit from the inception. Suit had to be filed in view of the fact that negotiation.
No, no. So if, well, let me hear Miss Manot. You're for the respondent?
I'm for the one respondent.
Microphone.
I'm
please.
appearing for the respondent number 1.
One. Yes.
My lord, I am the respondent number 1, my lord. I am the developer, my lord. Development agreement was executed, my lord. First,
No,
my
are you
lord,
saying there is no dispute?
there is no dispute. And my letter, which is we have given in reply on 4th of May 2023, has not been annexed to the petition.
To the 21 notice,
21 notice.
2nd April, not 4th May.
2nd April is there, letter, reply is on 2nd April, posted on 3rd
And what
April.
did you say in your reply?
In reply, we have said that there was no dispute between the parties as such. The developer always intended to develop the property. Tenants were there. Tenants did not vacate the premises. Negotiation, it was the owners to get the property vacated. However, we have taken the initiation. Litigation was filed before the court to have the property vacated. Without the property being vacated, your lordship, it was not possible on our part to develop the property. And your lordship, this was the first stand and there was no dispute. Secondly,
So are you saying that they did not terminate the agreement?
no, my lord, there were, my land friend is not the sole owner of the property. There are 2 owners, my lord. First is my land friend is one of the co-owner and the second co-owner is respondent number 2 and 3.
Yes.
This invocation of the arbitration clause is only on behalf of the one of the co-owner. And the notice dated 2nd April 2023, your lordship will find, has not been given to the respondent number 2 and 3. And
Yes. So you received it?
I received it, I have replied it. That reply has not been disclosed.
Yes.
And secondly, kindly see paragraph 7, arbitration clause, page 22 is clause 17. In the event of any dispute or differences arising between
Page,
the page 22A or 22, my lord,
Yes,
the
yes.
type copies at
Yes,
22C.
yes.
In the event of any dispute or differences arising between the parties in regard to this agreement, or any matter connected therewith, the same shall be first attempted to be amicably resolved by the parties inter se within a reasonable time, failing which the same shall be referred to and settled by arbitration of 3 arbitrators, 1 to be appointed by each party, and the 2 to appoint a presiding officer.
Very well. So 2 and 3, respondent numbers 2 and 3 are who?
Are the co-owners,
Co-owners with the petitioners.
with the petitioners.
Two is the owner,
Yes.
three is the confirming party.
Confirm.
What do you have to say?
It's true that since last 10 years.
Lordship, it is true since the last 10 years that no development has been made by the developers. So the tenants are
Yes, yes, you take it.
What are you doing? Yes.
few of the tenants have already been ousted. Lordship, few of the tenants are still residing over there. Lordship, no development, no progress is being made by the developers. Lordship.
So there's a dispute.
There is a dispute, Lordship.
Now, my lord, second point which I-
Lordship, one more thing, Lordship, we are residing over there. The respondent number 2. The petitioners are
The
not
co-owners.
the co-owners, one of the co-owners. We are sisters, Lordship.
Yes, very well.
Second-
Microphone, please.
Secondly, my lord, with regard to this, another thing, my lord, and before the division bench, my lord, because earlier they moved section 9 ex parte, thereafter they have preferred an appeal before the division bench. My lord, we have taken a point of maintainability. Of
That's over section 9 for the
section
division
9,
bench.
the filing of the proceedings before the commercial court. And that application. with
How is
regard
that
to the-
material here in a section 11?
Section 11 also, my lord, has been filed in the invoking the commercial court jurisdiction, my lord. And then, my lord, there is no attempt, kindly see the pleading. in the
Section
petition.
11? How
Section
can they do
11, my
that?
lord.
Section 11 is the chief justice or his designate.
Lord, what is the ground that has been made out in the application? For in sections arbitration.
No,
clause-
no, no, not required.
No,
Mr.
arbitration
Mr.
clause,
No,
my
no,
lord.
no,
Kindly
no.
see,
Mr.
no attempt has been made to.
Wait, just hear what the court has to
I'm sorry,
say,
sorry,
please.
sorry.
Yes, Mr. Chaudhary, where is your termination letter? Page 48.
48. Will
Have they not replied to this?
Lord, I suppose they have, Lord.
They have. Where is that?
But that's not an ex.
And why have you not annexed a reply to your 21?
They replied,
Some letter in May, which
That's
you
what
heard what
I-
your learned friend said?
Yes, I'm told that it's not there. Yes, yes, please file a supplementary affidavit bringing these on the. Yes, okay, yes, sir. Perhaps for that there's nothing to do with the section 11 application. Their reply to their your 21. They refused, it's very. No, no, why will you not bring?
It on record.
it's true, Lord, it should be there.
Whether it's relevant or relevant, completely the court's decision. You cannot decide that, Mr.
accept.
Chaudhary.
I accept
And
that.
if you have given a 21 and they have replied to that,
Should be
whether
there.
they have raised a dispute, whether they have said there is no dispute, the court must see it. The court will then decide whether it's relevant or not relevant.
Very-
Yes, bring those documents on record.
I'll do.
And come back when?
That,
In November?
The reopening, I'll give the supplementary affidavit by tomorrow.
Yes. The petitioners, who are the co-owners of a property along with the respondent numbers 2 and 3, seek appointment of an arbitrator in respect of a dispute between the parties. Stop. While the petitioners say there is an existing dispute, the respondents say, the respondent number 1 says that there is none. Stop. Next, the agreement between the parties is a development agreement of 15th December 2012, under which the respondent number 1 was to develop the property co-owned by the petitioners and the respondent numbers 2 and 3. Stop. Next, it appears from the submissions made by learned counsel appearing for the parties that the petitioner has not that the reply of the respondent number 1 to the petitioner's notice of invocation is not on record beside other documents. Stop. Next, the petitioners are hence given leave to bring on record a supplementary affidavit. Stop. Next, list this matter on 16th November 2023 as prayed for. Stop. Copies of the supplementary affidavits. Advance copies of the supplementary affidavits will be served on the respondents.
Grateful.
Satnam Global. Lordship, this was my application under 29A, Lordship. Lordship had heard this matter and had asked us to file a short points with regard to the page numbers that are relevant.
Page numbers, but
Yes,
no dates, no relevant
yes,
dates.
With dates and
Yes.
2 page, Lordship, I could bring it down to 2 pages. Lordship had asked for 1 page, I'm sorry.
My list of dates is a little bit more extensive because they have not annexed all the relevant procedural orders.
Yes.
There are, my lord, allegations of delay on the part of the respondent. My lord, look at the list of dates will reveal the delays on the part of the petitioner, not the respondent.
I have missed out, Lordship, 1 minutes, Lordship. I'll just hand it over to you, Lordship. Lordship, only 1 minute I'd like to,
Yes. Give a copy to
yes,
Mr.
yes, I have given, Lordship.
Das, please.
Lordship, this is within that 1 year period. They have again taken time on medical grounds. Lordship will see, after considering the request from both sides, it was granted. Counsel for the respondent by his email has
What is the date of this?
this is
26th
26th
May.
of May.
Yes.
Counsel for the respondent by his email has intimated the respondent's witness is on leave on medical grounds and presently at Chennai for availing treatment. According to the counsel for the respondent has prayed for 3 weeks extension of time to file its affidavit of evidence. The prayer of the counsel respondent accepted for the reasons stated in the email. Additional 3 weeks time.
And this was during which
Yes,
period?
yes, within that 1 year.
29A1.
Yes, absolutely. Just for the purpose of 30 seconds for the recapitulation, Lordship, 30th September 2022, the.
No, have you
pleadings-
not said that in your
Yes,
note?
Yes, I have said.
Have you?
I've said that. Relevant dates, Lordship, first portion, Lordship.
And you're taking the pleadings together with the rejoinder or
Yes,
something?
yes, yes. my lord.
Your rejoinder
Yes,
to their counterclaim,
to their counter statement.
to their counter statement.
Yes,
But we don't have a counterclaim. It's a statement of defense.
yes. I'm taking rejoinder by virtue of their statement made in the application. Lordship recalls that rejoinder can be treated as part and parcel of that 23-4 Lordship. They have mentioned in their application for extension of time to file written statement.
And what is your answer to, what is it, 23-4?
23-4.
Yes,
That is
what is
their
your-
pleading. Their pleading, Lordship will recollect, Lordship will kindly have a look at the
I
application.
don't recollect anything, you tell me.
I'm sorry, Lordship. Will kindly have a look at their application at paragraph 9.
Yes.
This was their application, second application filed for extension of time to file counter statement, Lordship. Paragraph 9, page 4. It is I'm sorry,
Yes.
page 4, paragraph 9. It is humbly submitted to the.
No, I remember this.
Yes.
But what is your answer in law to 23-4?
23-4 Lordship, they accept, once they accept that this is part and parcel of the pleadings that is necessary, then anything further cannot be. The law says that pleadings are to be complete and they accept. Once it is accepted by them that rejoinder comes within that purview, Lordship, I need not go further because that is accepted by the parties to be this way, Lordship. And with regard to the dates, Lordship, for the date it is ending is 1st of October 2023. I'm repeating myself also. The first date gets excluded by virtue of section. It's all.
Lord, on the point of delay, my lord, just 2 dates I'll point out. First is, my lord, after we filed the statement of defense, they took time of 6 weeks to file a rejoinder. This is when the 29A had started according to us. After that, my lord, even if your lordship takes after the rejoinder, they took 2 weeks additional time to file additional documents, which they had ample chance, my lord, to do it with their statement of claim and even the rejoinder. After filing rejoinder on 17th October, my lord, they have taken 2 weeks time. After that, there was direction to file the affidavits. We took time of 3 weeks for medical grounds, my lord, but that became OTOs because then they made another application, my lord, for filing 3 volumes of additional documents. And my lord, the inspections were to be carried out in New Delhi, in spite of the seat being in Kolkata. This led to, my lord, the overall delay. My lord, within a period of 1 year, they have shown 3 weeks extension from our side.
In the entire period of 1 year, they have twice filed, my lord, voluminous additional documents, which led to supplementary affidavits of admission, denial, inspection, discovery. And this is what, my lord, delayed the entire time. But I've placed the list of dates. My lord, if your lordship allows me to file an affidavit in opposition, I'll place all the procedural orders as well.
So what did both of you do? You submerged the learned arbitrator with documents, both of you.
My lord, we have not taken a single extension for additional documents. We
The
have just filed
vital-
a statement
The
of intent.
vital point, Lordship, I bring up this issue, forgetting everything. I bring up this issue that I am required to get a 6 months extension 1 month prior to that ending. And they played along all that time. Had they objected to it, they had the right to object. There's no hard and fast rule that they have to give consent. Had they objected to it, my application would have been on the board 1 month prior thereto.
Very, yes, that's learned counsel appearing for the petitioner who seeks extension of the arbitrator's mandate. And a learned counsel appearing for the respondent who opposes the prayer for extension, comma, have handed up their respective short points. Stop. Next, reserve for judgment.
I remember.
I have relied on one order which I had stated on the last occasion, passed by the Honorable Bombay High Court, on the
Yes,
point
yes.
that after, I'm just placing that.
Yes,
order,
yes.
I'm giving a copy to. I
I-
relied on it in my written notes.
There are 2 further orders if this is relied on. This was not placed earlier. 2023 judgments are there of Delhi High Court and Bombay High Court. I did not because there was nothing mentioned by them during the arguments.
But there's a judgment of this Honorable Court. It is bolstering it with, by showing there was a prior order which was not shown at that point.
Very well. Yes.
One of Bombay High Court, one of Delhi High Court, also I'll hand it over. to
Mr.
you.
Shaha,
I'm
I will not look at
Very-
this Bombay High Court order, all right?
Very
Yes, next.
Right.
Grateful. you.
highly privileged.
Fifteen, Fountain Enterprise.
That I can't prove, to be responded. For my learned friend is here.
Yes. You want extension, Mr. Chaudhary?
Yes, but arbitration agreement, my lord, went past. The time, my lord, went past. So, my lord, in view of my lord's judgment, my lord, I can't, my lord, file and maintain a section 29A. So what I have done is, my lord, I have set section
No,
29.
you wait, I can put this matter beyond. You wait for the Supreme Court to decide. It may get set aside and then you have a
So-
case.
So I have, my lord, kept that window open for myself.
Yes.
And I have, my lord, put in 29A, and I've also made an alternative case under section 15 of the Act.
So you want the arbitrator to be removed
The arbitrator is removed, my lord, because it went on. Nobody objected. Ultimately,
and went on for how many years?
my lord, around a year and a half.
Year and a
And
half?
yes, my lord, when the time came, my lord, we filed notes of argument also. Ultimately, my lord. it
Unfair
was
on the arbitrator.
unfair
One
on
and a
the
half
arbitrator.
years, the record is 9 years. What I've heard, member of the Bar Library Club. Yes. What do you say?
It is. After, my lord, the matter was made CAV. The question which arose was, when does my time come to an end? All of us had missed. I had missed, my learned friend, my lord, who's appearing from Bombay had missed. The learned arbitrator had missed. Then we discovered that this is the situation. And the law, my lord, has now been laid down by your lordship. My lord, so that is I have to accept that position. Now, I can't wait, my lord, indefinitely till the time the Supreme Court, my lord, decides this way or that way. If it, my lord, affirms my lord's judgment, then I will be wasting more time. On the other hand, my lord, if I come under section 15, my lord,
So you can wait till the, I don't know, what is the
I don't
status
know
of the
whether
Supreme Court? I
anybody
can put
has
it after the
gone
vacation.
up, my lord. I don't know whether anybody has gone up. I,
Yes,
my lord,
yes, they have. That's what was told to me by Mr. Das, the previous matter. Yes,
my learned friend was also there in one of those matters.
yes.
Not, may I do this, my lord? May
Yes.
I come back on the reopening date? If by then nothing happens, I'll, my lord, proceed under section 15.
So you want the mandate to terminate as well, substitution.
Mandate is already terminated as one substitution. It can be the same person, but here, my lord, I must point out what had happened was that we made a unilateral appointment of the arbitrator.
Yes.
There is a document on which they say
which I say they have signed and accepted.
the appointment.
12.5 proviso.
Yes. So they say that, no, that is not my signature. So
Yes.
that is a matter which was made subject matter of a section 16 application and then ultimately left to be decided at the time the award would be passed. Which is why, my lord, in all fairness, they will not give consent towards section 29, to appointment of the same arbitrator. I understand that position completely and I would have done the same thing.
Yes.
So having regard to the two things, number one is the uncertainty, because what's going to happen in Supreme Court is not known. Secondly, I have a good case. It's not unpaid rent. I don't want this issue of consent to come up and be the only point which they can argue
In a 34.
in a 34. So even if I go to somebody else and I have not paid remuneration of the learned arbitral tribunal, the only person who will suffer prejudice is really me. So, my lord, I don't mind going to a neutral person, getting an award, which I will not, we feel that we are entitled to. And then, my lord, this argument about jurisdiction of the learned arbitrator will be, my lord, gone. Which is why I didn't even say, my lord, that please appoint the same.
And when did the mandate terminate?
In terms of the case that has been made out, by the petitioner, the mandate had terminated on 22nd of November 2022.
When, my lord, the 1 year period expired, then, my lord, parties continued. We found a.
You did not give your
No,
consent?
my lord. I do not give consent because from the very beginning I have been challenging the mandate of the arbitrator because it has been unilaterally appointed.
And there's no proviso 12.5 by you?
No, my lord. Nothing has been indicated, only on the basis of a letter that they have issued. They claim that I have put in my stamp and seal on
Very
the
well.
basis of
Mr.
which.
Chaudhary, I'm putting it on the reopening day. If you get a judgment from the Supreme Court before that.
Then before the same learned arbitrator, otherwise your lordship will appoint
But
anybody
even
of
if it
my
is
lord's choice.
before the same learned arbitrator, that will not take away his point of unilateral appointment.
Yes.
And my lord, I
And
oppose.
I have to prove my document, which I have. So, my lord, another way of looking at it is, if I go before a neutral person,
So
then,
what do you
Milord,
want? You want to press your 15.2?
if I walk that path, my lord, then the only argument which they've been making in arbitration that letter contains a forged signature of the respondent, that goes away. Now it's only on merit. It's before a person, my lord, who's.
Very well. I'm putting it on
First
16th, or I can also substitute if you want, whatever you want.
May I just think?
My lord, I am
Not on the
opposing.
reopening day, my lord.
And I'm opposing the issue with regard to substitution under 15.2 because, my lord, in case there is a substitution, that has to happen under 29A6 and not under 15.2. My lord, the reason being the court at the time.
29A6 is when the arbitrator can't pronounce the award
No, my lord,
within
29
time.
Then, my lord, 29A7, my lord, is where the, my lord, in the, my lord, 29A6, while extending the period in reference to the subsection 4, it shall be open to the court to substitute one or all the arbitrators, and if one or all of all the
No,
arbitrators.
substitute on what ground? That they have not been able to make the
Yes,
award?
ma'am.
That is what I'm asking you.
That is a 29 extension.
My lord,
When your lordship is extending on the 29, your lordship may substitute. That is, if your lordship is extending on the 29, your lordship has held that after the time has lapsed, I cannot come under 29 because the mandate is terminated. Arbitration proceeding is still pending. There's a difference between pendency of proceeding and pendency of mandate.
Yes, Mr. Dats.
my lord, the reason being this application is principally under section 29. And the release that has been sought is also under section 29A. So in case the substitution has to happen, it has to happen under 29A7 and not 15. 15 has been indicated as an alternative relief in terms of their letter at page
No,
105,
15 follows from 13 and 14.
13 and 14. My lord, this is not a case of 13 and
So
14. but-
15 is not a case of, 14 is of de jure de facto
Yes, ma'am.
inability,
Yes, my lord.
ineligibility or whatever, unable to perform.
That case has not been made out in the petition, my lord. It is a specific case that they are seeking extension of this particular mandate, and an alternative case has been made out that in case the mandate is not extended, then a substitution under 15. Whereas my submission would be.
Very well, very well. We get so additional point which needs to be decided, something to look forward to in November. Yes. Yes,
And my lord, I'm appearing under an undertaking to file a wakalatnama.
yes,
Just one thing may I indicate.
yes.
My lord, I am before your lordship, because section 29 also, my lord, gives your lordship the power to appoint. So, my lord, power to appoint is only inherent in this court. So, my lord, I can't go before the commercial court or any other court. There is a reported judgment, my lord, on this.
Why are they saying that you need to go to the commercial court?
This, my lord, the point may be taken. So, my lord, I am just indicating. I can't go. Section 29 and section 15 is exclusively before your lordship and no other court in the state.
Very well. And of a coordinate bench? Yes.
Then may I submit a copy by lunch, my lord?
Yes, yes. You can give it before also, then I can, that will be my lunch reading. Yes,
I shall do.
The learned counsel appearing for the petitioner submits that the mandate of the arbitrator, of the learned arbitrator, terminated when in November 2022.
22nd November 2022.
On 22nd November 2022.
stop. Council therefore seeks an alternative, prays for an alternative order of substitution of the learned arbitrator under section 15 within brackets 2 of the 1996 Act. Stop. Next, admittedly, comma, the respondent did not give its consent under section 29A within
Brackets 3 of the Act. And now says, comma, through learned counsel, comma, that any substitution which is called for may have to be made, or will have to be made under section 29A within bracket 6 of the Act. Stop. Next, this point will also have to be looked into on the returnable date, which will be 16th November 2023.
Also, I thought that I object to the appointment of the same arbitrator.
You,
I object to the appointment of the
very well. Yes.
same.
Yes.
Item number 16, approved of capital was the last approved.
Lordship, this is my section 9 application. On the last day, I had produced a reply by the respondent where it said that they will appear on 16. Lordship had given me another direction to serve upon them. Lordship, we have served yesterday. Lordship, they have given a reply to that saying that we have attached our reply. We could not find an advocate. This will remain our final word. We shall attach a letter to court via speed post. As a part of the management, this is the last we can do. Lordship, the attachment is inadvertently not there, but the attachment is related to a separate matter. We do this. I will put it after the vacation. All right. Lordship, in that case, if I can only pray that a show cause order be passed against them as to why they won't secure the amount. No.
Come back on very well, I will put it on 19th. Yes, the advocate on record of the petitioner refers to a message/mail sent by the respondent saying that the respondent is unable to engage a lawyer to represent them. Stop. Lists this matter on 19th October 2023. 19th November.
On section 9, no? Section 9.
17 Cholamanam investment.
This is my section 9 application. My lord, Mr. Shuddho Shatto Banerjee had taken a point of maintainability. He was arguing. Lordship has heard him. So, my lord,
Which one is that?
My lord, this is with regard to section 42, my lord, he wants to show. And my lord, whether CPC will apply. Now, my lord, if he finishes, I'll give the reply, my lord. I'm ready, my lord. Otherwise, my lord, I cannot, my lord.
Yes,
But he is there also from there. And
a learned counsel who was who had argued the maintainability, who had argued against the maintainability of the present application is not present in court. Stop. List this matter on, give me a date in November.
my lord, I am pressing for an interim order any day on the reopening lordship keeps, my lord.
List this matter on 16th November 2023, considering the fact that learned counsel representing for the petitioner is seeking an interim order.
Grateful.
Next. Seeks an interim order.
Great.
Yes, new chamber.
New chamber application, item number 26, contemporary brokers.
Sorry, my lord,
Yes.
this is where, my lord, they had, my lord, on the last occasion.
Yes,
my
yes.
lord, given us, my lord,
Yes.
my lord, they really, my lord, they want postponement of their obligation, my lord, to pay by 1 year. That's my lord what the chart is. My lord, I've spoken.
I remember Mr. Chaudhary handing up something. on
Yes,
this.
yes, my lord, this is the, I don't know whether, my lord,
Yes.
anyway, my lord, be that as it may, my lord, perhaps, my lord, court will not, my lord, really, but my lord, I've taken instructions. My lord, if they provide, my lord, a guarantee of some sort, my lord, from their, my lord, the company, my lord, which is the main company, my lord, we,
How much was left? 1.5.
no, my lord, 525 and 175, my lord, about 7 crores.
7 crores. Yes, Mr. Chaudhary.
7 crores, my lord, if there's a corporate guarantee, my lord, given, my lord, by the MRIL, my lord, because otherwise, my lord, we feel, my lord, that this will really, my lord, way to, my lord, stall, my lord, further orders.
Yes.
50 lakh, I said I'll pay today.
McLeod is going through, McLeod is going through corporate restructuring. I don't want to make an incorrect submission. I am
That's the
aware.
flagship company.
That's the fact.
My lord, I don't know whether he's aware of, my lord, I took.
I put the question to him simply because he was not there in court. That's why.
Let's have a look at that. Yes.
Yes.
So, Millard, I know what the answer will be, that the bankers won't permit us to give any corporate guarantee. So, Millard, this is the situation. I have been able
Or
to.
personal guarantee, sorry, personal guarantee
Personal
also.
guarantee.
Personal guarantee also, either corporate guarantee or personal guarantee, whatever.
देबे? कितना percent?
How can Mr. Shorkar tell you that? Can he?
He is not the authority on the flagship company.
Yes.
We paid half. I used to come and try and convince Mr. Banerjee to permit us to have further time to make payment. Till the time we were not convinced
Oh, you
ourselves.
said something about November 2024 on the last.
Yes, but then now the client has failed to pay. So that is the difficulty. Millard, may I do this? If they agree, Millard, to extend Millard without a security, that we'll immediately pay 50 lakhs. And Millard, on the next default, Millard, Mr. Banerjee can renew his prayer. At least, Millard, we've
No,
paid
you were
half.
supposed to pay how much?
The 1 crore 50 was supposed to be,
1
that's the
crore
one which is
50, but-
outstanding.
1 crore 50.
Millard, these
As on
companies,
today.
Millard, if it goes into IBC, Millard, he's also aware that he won't get anything. Millard, in this way, Millard, whatever is getting liquidated, Millard, let it happen till the time, Millard, there is a.
But,
I
then,
was
my lord,
thinking that.
we'll press, my lord, for whatever orders,
Yes,
my lord.
you're
Because otherwise, my lord,
entitled-
I also, my lord,
you're
can't take
entitled to.
responsibility. If I tell my client, yes, let us wait. And tomorrow, my lord, again, my
Yes,
lord, he
yes.
comes and,
No,
because we have quite naturally, my lord, since, my lord, we are receiving, my lord, money in, my lord, whatever form, my lord, driblets, my lord, we are also accepting. But, my lord,
No, that company is undergoing restructuring. That's what you had said.
McLeod is.
Then why are you saying it will go under IBC again?
Millard, anything can happen. There are petitions pending against. both
Restructuring means it's emerging out of that. Then why are you
Yes,
saying again
yes.
IBC?
Somebody else might come if it doesn't succeed. I don't want a situation where, Millard, the petitioner or the decree holder waits and under expectation of getting payment because of, Millard, submissions made by us. and then ultimately the company goes into ITC.
we'll
I
take
don't want that
We
situation.
take the risk of a corporate guarantee from MRL. We have no difficulty.
But I can't give that to you because the bankers won't let me. And this, I'm told, my lord, MRIL has paid over 25 or 30 crores this month to clear off provident fund dues, which is why, my lord, the group is in this situation. Lord, if it survives, we will definitely pay them. Now it's not on them. If they ask for orders, I can't oppose.
Mr. Banerjee, what will be the effectiveness of an order if I were to say that you secure, if the banks don't give that money or that guarantee?
It may not, my lord. In the end, it may not. But, my lord, I'd like to examine, my lord, the directors to find out, my lord, where the assets are. Because I'd also lend money to, my lord, them. We got a decree. My lord, they promised, my lord, this is how they're going to pay. This is the assurance given. Now, my lord, there's already, my lord, a default with regard to, my lord, at present, my lord, there's a default of, my lord, 1 crore 50 or 2 crores, my lord, I think 1 crore 50. My lord, they say postponement 1 year. I've only said that at least give us some kind of assurance that because your flagship company, I'm sure you'll protect that company. So give us a corporate guide. It's not such a amount, my lord. If they're paying 30 crores, 40 crores, my lord, it's only, my lord, a question of 7 crores. They can give us a corporate. We'll be happy with that. That the flagship company has also put its
I
really interest in it. That's the only assurance, my lord, we will have. Otherwise, my lord, I'll have to
agree.
What kind of guarantee do you want? Corporate and personal?
Yes, my lord, corporate, my lord,
Corporate guarantee.
corporate guarantee or, my lord, if, my lord, they can, because promoters are the main people. I don't want, my lord, someone else to be a director here, my lord, and they'll say, sorry, the company is gone and nothing you'll get out of it. Because as of now, my lord, I'm entitled to, my lord, really proceed against this company and against its directors. With regard to being examined, my lord, and
Yes, and you got a decree of 11.50,
yes, my lord.
out of which now 7 is left.
My lord, yes, 7 is left.
Yes. My lord, one request.
With
my
interest,
lord.
it's 8.5, my lord, because interest was also provided, my lord, in the
As regards, my lord, MRIL, my lord, I had made a statement that this payment, etc., has been made. I would request your lordship, my lord, not to, my lord, record that because everything goes back to the bankers. If we agree in that restructuring with the bankers, then it will all work out. If that fails, all these companies will.
No, I will not record that. Not record which one? The provident
Anything
fund.
about MRIL, my lord, the flagship.
Yes, yes.
and that 50 lakhs, my lord, they were also supposed to give today, my lord. I think, my lord, that was the
Yes,
assurance given, my lord. Otherwise,
yes.
each I chose.
The orders show that the earlier orders passed by this court show that the respondent award debtor was to pay approximately rupees 8.50 crores to the award holder in terms of a decree, in terms of an award dated
Decree, my lord.
a decree holder, judgment debtor. In terms of a decree
25th February.
yes, dated 5th February,
25th February 2022.
25th February 2022. Stop. Since the award debtor was in financial stress, the court passed several orders. Court passed orders from time to time directing the award debtor to pay sums of money in part satisfaction of the decretal amount. Stop. Next, the award debtor was to pay rupees 50 lakhs, in addition to what it had already paid earlier, was to pay by 29th September 2023. Stop. The award debtor has not paid this amount and now seeks a time, time till, what did you say, November 2024?
Yes.
November 2024 to pay the entire outstanding amount of rupees 8.50 crores. Stop. Next. Since the court has been informed that the flagship company of the award debtor, of the decree hold, of the judgment debtor is undergoing a restructuring process, and the award debt and the judgment debtor has not been in a position to comply with the directions for payment, with a few of the directions for payment,
It is only fair that the decree holder is secured to the extent of the outstanding amount, which is the principal component of which is rupees 7 crores. Stop. Next, the award, the judgment debtor shall accordingly furnish a
corporate guarantee securing the amount of rupees 7 crores in favor of the decree holder within.
Can't will not agree, will not. No, your lordship could make the direction, but may I see two things, Lord. It's not, Lord, as per the decree, I may not be able to do this, Lord.
Mr. Chaudhary, if you can't do this, then you have to come back to the court. All right. The court doesn't pass orders seeing
No, I
what can or cannot be done, in all fairness. Yes, give me a reasonable time.
I think, Lord, the vacations. And Lord, if I can't do it, I come back, and then Lord, if I can't do
No,
it, the
how much time
actual
do you
fall.
want to give that?
Lord, give me Lord 30 days to Lord furnish. If I can't, then Lord, the actual
30 days,
fall of the opening.
yes, 30 days would be the reopening.
Yes.
Ki bola within bola? Within within 4 weeks from today. Stop. List this matter on 20th November 2023.
Grateful.
The 50 lakhs, Mr. Malad supposed to give us today,
Kindly direct me to make that payment.
The judgment debtor shall also pay 50 lakhs, as was directed by an earlier order passed by this court, within the returnable date.
But it was to be, Malad.
29 September. It was to be paid by
Yes,
29
yes, Malad,
September.
if Malad, they can give that, Malad, because they were supposed to give it today, Malad. That's what at least, Malad. No, that's what, Malad, they say also, Malad, that they will pay it, Malad, on the 17th. Where's that letter?
Yes, within the returnable date, na kore koro, by what is the time? 19th.
19, Malad. In fact, they say only if you accept it, then only we'll pay. Malad, it can't be like that, Malad, that the
Yes, by 19th October 2023. Yes, call the next matter, please. Item
number 27, RB Rail Products.
But I appear for the decree holder. On the last occasion, Lordship had permitted me to file a supplementary affidavit, which was necessary for clarification of the decree. But I filed it in your Lordship's record, but I have served it also. May I file the affidavit of service?
What is it that you want today, Mr. Dashgupta?
But I have served it on the judgment debtor, but they had
Come back when? Tell me.
after the vacation.
The second Thursday? Yes, the supplementary affidavit, what have you handed up?
But I've handed up the affidavit of service. The supplementary affidavit was filed in court.
Very well. The affidavit,
It's
the
filed on
affidavit
6th of
service is kept on record. Stop. No one appears for the award.
Decree.
No one appears for the judgment debtor. Stop. List this matter on 23rd November 2023. The decree holder will communicate this order on the judgment debtor.
Grateful.
28 with the South City project.
They should be executed. Your lordship order last day, kind of said it all. They were supposed to ward off bank account injunction and or to deposit the money they had offered. You can see last day's order, decree holder seeks to proceed with the matter, yet to receive 1.76 crores. Judgment debtor, on the other hand, seeks to pay at least one of the 12 installments they wanted without prejudice to its right. He said 25 lakhs. Learned advocate counsel for the judgment debtor also offers to keep one flat as security in part satisfaction of the decree. Since judgment debtor is not in a position to give particulars of the flat in terms of value, let's this matter. No flat, no particulars given to us, no money has come. Lordship, so my lordship, I would, they were supposed to give 25 lakhs.
So that is trying to give you something.
This piece of paper and lordship, let them keep their money about. Let them keep their money about.
He's right, I should have given it before the.
This is something we have experienced with this client, not with Mr. Doctor or some other.
Mr. Mitra, I will keep it on Thursday.
I will
Alright?
check.
You check the value and whatever, and
And take it, this is unencumbered.
it's 1.76 crores.
1.76 crores.
Yes, so you see whatever
is what?
valuation this will fetch.
And I take it as unencumbered.
Yes, learned counsel appearing for the judgment debtor. Hands up valuation sheet of,
Not valuation, only particulars.
hands up the particulars of the flat which the judgment debtor is offering by way of security in satisfaction of the outstanding amount of 1.76 crores in terms of a decree passed by a coordinate bench. Stop. Next, list this matter on 19th October
One more thing,
2023.
Lordship, kindly see that the first page of the order, second paragraph, the judgment on the other hand seeks to pay at least one of the 12 installments
Yes,
without prejudice before the matter is taken up by the court. So even that has not come.
and one installment is how much?
He had said 25, but then now it seems whatever, some
25 lakhs,
15,
50 lakhs,
15, 1, 5.
1.5.
12 lakhs is his own.
Yes, Mr. Dutt.
My learned friend, when I offered on the last occasion, my learned friend was not agreeable to take. My learned friend did not agree to take this offer. He says that he wants to pursue the execution application whole of. Thereafter, your lordship intervened and said that at least take inspection and see what's the value of the flat. So he's never indicated that, although I still need to wish to argue that there is no decree in the eye of law. But for the time being, since the decree is there, I am to comply with it in some sort as your lordship so desires.
My impression was to show their bona fide, they were going to pay us this much money and to give us, after all, money is payable to me.
Mr. Mitro, if you see, check
Very well.
the valuation of the
Yeah, I
flat
can
and
ask for
then we shall see.
Fine.
Yes,
These concessions are without prejudice to that point of my fact. There is no decree.
Yes. This is matter on 19th October 2023. Stop the security offered by the judgment debtor is without prejudice to the argument, to its argument.
on the sustainability of the decree. Yes, call on the next matter, please.
New chamber application arbitration item number 29, party invest EMCC. This is my application for execution. My lord, they have taken point of section 48 of the Arbitration Conciliation Act. It's a foreign award.
Yes.
my lord, they were submitting on the issue of the award being in violation of the public policy in as much as, my lord, the terms of the Customs Act had been ignored while passing the award. My lord, I raised a point of security being provided for on the last occasion, which Mr. Banerjee was supposed to respond upon today.
Yes. Yes.
But if they can respond on it, because I had produced the judgment, the citation had also been indicated.
Yes. I remember you're praying for it, but I don't remember the point.
Judgment was placed. The judgment is yet to be placed, Madam Chairman.
Very well, my lord.
I remember that you wanted an order,
No,
but I don't
that's-
remember the judge or any judgment being placed
Well, I'll please.
or the provisions of the CPC,
Yes, my lord.
the Arbitration Act.
If your lordship is pleased to. This is a coordinate bench judgment. This is reported in AIR 2004 Calcutta 142. My lord, paragraph 9. From the provisions contained in section 47.
You're the award holder.
I am the award holder, my lord. 48 and 49 of the Act, it is
1
clear.
minute. Paragraph.
9, my lord.
This is on what proposition?
On the proposition that, my lord, despite of the issue of maintainability being pending before this court, my lord, the court is entitled to pass orders of
Yes,
interim
yes,
prayers,
yes, very well. Yes.
interim release for the purpose of protection of the award holder.
Yes.
My lord, from the provisions contained in section 47, 48 and 49 of the Act, it is clear that both the parties can approach the appropriate forum with their respective prayers. That is, the person in whose favor a foreign award goes can definitely apply before the competent court for enforcement and execution of the award. At the same time, the person against whom the foreign award has gone can approach the court for setting aside such an award. True that before proceeding to execute a foreign award as a decree of the court is required to record its satisfaction that such a foreign award is enforceable. But this, however, does not mean that in a pending application for enforcement and execution of foreign award, the court cannot pass any interim order in order to protect the interests of the person who applies for enforcement and execution of a foreign award. The interim reliefs can be granted in such an application in need of the final reliefs. But I must indicate, my lord, there was an appeal carried from this order. My lord, the appeal, my lord, proceeded on the basis that the award was not a foreign award. And my lord, the order was set aside. But with regards to the observations, with regards to the power of the court to grant interim reliefs, the appeal court did not go into it, and there is no different view expressed by the appeal court. Now, my lord, the 2021 judgment of the Supreme Court with regards to execution and suits in case of money claims, the Supreme Court, my lord, has categorically held, this is a judgment report in 2021, 6 SCC 418, paragraph 42. Now, this is the general law. Paragraph 42, your lordship has that?
This is usually that,
Yes.
order 38 rule 5.
Yes, my lord, order 38 rule 5 in the Supreme Court is very categorical on that. All courts dealing with suits and execution proceedings shall mandatorily follow the below mentioned directions. And my lord, I am relying upon
Paragraph 42, which
42,
42? Yes.
I'll just indicate which one, my lord. My lord, paragraph 42, 5, the court must, before passing the decree pertaining to delivery, 42.6 in a money suit, the court must invariably resort to order 21 rule 11, ensuring immediate execution of decree for payment of money on oral application. In a suit for payment of money before settlement of issues, defendant is to provide the court exercising jurisdiction under section 47 or under order 21 of the Code of Civil Procedure must not issue notice of an application on a third party claiming rights in mechanical manner.
You're reading 42.8.
42.8.
42.8.
Yes, my lord.
Yes. Yes.
Further, the court should refrain from entertaining any such application that has already been considered by the court while adjudicating the suit, or which raises any such issue which otherwise could have been raised and determined during adjudication of the suit if due diligence was exercised by the applicant. 42.9, the court, while allowing taking of evidence during the execution proceedings only in exceptional rare cases where the question of fact could not be decided by resorting to any other expeditious method like appointment of commissioner or calling for electronic materials, including photographs or videos or affidavits, the court must, in appropriate cases where it finds the objection or resistance or claim to be frivolous or malus vitae, resort to sub-rule 2 of Rule 98/21 as well as grant compensatory costs in accordance with
So
section
what is
40.
what do you want to say?
I want to say this, my lord, in terms of 42.1, my lord, these directions have to be followed, and in effect, my lord, my claim has to be secured before, my lord, maintainability is decided. I have a claim on account of a foreign award, but and the interest is running. Today, my lord, the computation has gone up to 1.4 crore. They have filed an affidavit of assets, my lord. I want an injunction restraining them from operating the bank accounts or dealing with the assets without keeping
And
apart.
the foreign award is of which date?
My lord, foreign award is 2018, my lord. So it is dated 22nd of August 2018.
And what was the amount?
My lord, 1,14,62,254, including interest. And my lord, the affidavit of assets have been filed only on September 5, 2023.
And what is the status of the execution? Nothing after affidavit of assets?
Nothing.
So, and they are arguing a point of maintainability.
Question of maintainability, apropos, my lord, the Customs Act, no provisions of the Customs Act specifically has been relied upon. What has been said that it's in violation of the public policy. My lord, they had the remedy of going up in appeal in terms of the GAFTA rules. They have not preferred an appeal.
GAFTA rules appeal, there must be a time frame.
Yes,
That's
my lord.
gone.
Clause 10, my lord, of the execution application, page 17. It shall be 30th consecutive day, clause A, my lord, 10.1.
Right of appeal.
Yes, my lord. 10.1, clause A. Save as are providing rules 6.4, 8.1b, 8.2, 19 and 21. Either party may appeal against an award to a board of appeal provided the following conditions are complied with. A, not later than 12 noon on the 30th consecutive day after the date on which the award was made. The appellant shall ensure the written notice of under GAFTA, serve a notice of his intention to appeal on the other party, ensure receipt of a copy of by GAFTA, and ensure GAFTA had received cleared
Yes,
funds.
that's all right. So obviously that went, that's
ma'am.
30th. Where are you reading the 30th?
Well,
consecutive
30th is 1A, page 17, 10.1
day?
A. Not
On the
later than,
30th consecutive day.
yes, my lord.
So it's of 22nd August
Yes,
2018.
that
So
timeline has
obviously-
expired. And they
Yes.
have not taken up these points in appeal. They have not preferred an appeal. And my lord, the last sentence rightly pointed out by my learned friend of the same clause at page 17. Otherwise, the right of appeal shall be deemed to be waived and barred. And 48, my lord, after the amendment has come into force, your lordship sees explanation 1 to section 48 of the Arbitration and Conciliation Act. My lord, for avoidance of any doubt, it is clarified that an award is in conflict with public policy of India only if the making of the award was induced or affected by fraud or corruption or was in violation of section 75 or 81, or it is in contravention with the fundamental policy of Indian law, or it is in conflict with the basic notions of morality of justice. Explanation 2, for avoidance of doubt, the test as to whether there is contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute.
So it's same as 34.
Yes.
Yes.
I was pressing for prayers for the purpose of, my lord, attachment of the bank accounts disclosed at paragraph 5A of the affidavit of assets. And, my lord, because I do not think as on date there will be any funds.
Paragraph?
5A of the affidavit of assets, my lord, filed on the 5th of September 2023. It only discloses that the
So
bank
you want,
account.
what do you want? 5A? You
By
want,
way, they should not be permitted to operate the bank accounts without keeping apart a sum of rupees 1 crore 14 lakhs, which evidently is not there. And my lord, I would also be praying for
evidently is not there means what?
my lord, because the bank balance shown in the paragraph under reference, my lord, shows that the 3 bank accounts has a balance of approximately 13,60,442.
And how much are you saying? 1 crore 14?
1 crore 14 as on March 2021, it has increased to around 1 crore 40.
Yes, Mr. Banerjee.
3 things. That injunction, whether it be in a suit or in an execution application, it's an equitable relief.
Yes.
3 dates your lordship will kindly make a note of. I hear that angst in Mr. Ghosh's voice, and I understand why. The award is dated 22nd of August 2018. Your lordship will find from a tabular statement, it's already called a decree. That's not the law, it's not a decree. I shall show the Supreme Court judgment. One, I understand the paucity of time now, that I will not take much time. I'll just quickly give my points. 22nd August 2018 is the award. The execution is filed after 3 years. Because it's filed after 3 years, they have to give me notice. Otherwise, they would have been covered under Rule 12. So much for my delay, all that. So after 3 years, they come.
Yes.
2021, this execution application is filed. March 2023, initial prayers were made for affidavit of asset. The court refused it. I don't think either of us will be able to show any order, but because Mr. Ghosh is there, I'm going to take it that he'll agree to this.
Court refuse what?
For any affidavit of asset.
Yes.
On the last occasion, my affidavit in opposition to the execution application has been filed in March 2023. Thereafter, the affidavit of asset was filed immediately before the summer vacation, if I'm not mistaken. The last day before the matter was being called, he pressed for this. Again, when I'm arguing my objection to this, in the last minute, he presses this injunction. But in all these days, this is calculatively done. So the court is put under pressure to return a finding. And very consciously I'm making this effort because throughout these days, not once does he press for any other order. Every day, every time, I won't say every day, every time it's heard, no prayer is made. Every time, 2 or 3 days before the vacation, a prayer is made before the court. The court is put under pressure. There is paucity of time. And for that, we've given an affidavit of asset showing Rahul S. Shah, my lord, it is not the law. With regard to applications for execution of a foreign award, and I don't say it as a decree because of section 49. Kindly have a look at it.
Yes, I'm aware of 14.
Section 49, it is where the court is satisfied that the foreign award is enforceable under this chapter, the award shall be deemed to be a decree of that court. So first, this is again covered in the recent Vedanta judgment. This satisfaction will have to be returned for it to partake the character of a decree.
Yes.
This is paragraph 82. It is also green. This is 2020, 10 SCC, page 1. Paragraph 82. May I?
Yes.
A foreign award is not a decree by itself, which is executable as such under section 49 of the Act.
Yes.
The enforcement, 2020, 10 SCC, page 1. The enforcement of the foreign award takes place only after paragraph 82.
Yes, Sahib. Yes, you can read on.
Yes. The enforcement of the foreign award takes place only after the court is satisfied that the foreign award is enforceable under chapter 1 in part 2 of the 96 Act. After the stages of section 47 and 48 are completed,
yes,
the award becomes enforceable as a deemed decree as provided by section 49. The phrase "that court" refers to the Indian court which has adjudicated. This is important. The phrase "that court" refers to the Indian court which is adjudicated on the petition filed under section 47 and the application under section 48. So first there has to be a satisfaction post an adjudication.
Yes.
And this, my lord, it fails me how throughout he always sits through the hearing. And just before the summer vacation, there's a prayer for injunction. Just before the long vacation, there's another prayer for injunction. How does he explain today? And that's the first hurdle that I thought he'll have to cross. From 2018 to 2023 October. How does he explain his client stand like this? It's all very fair to say court can do it, but it's an equitable relief. You have to show these are essentially in the nature of pretermit action. My affidavit of asset is on record, and this was his apprehension that I will deal with my asset and fair apprehension. Now he knows what my assets are. They are before the court.
Anything else, Mr. Banerjee?
Just one, my lord, hackneyed, but just one set of judgments. This
Set of
2002
judgments, what do you mean? How many?
One. It's not
Yes.
set. Because I hand over said.
Yes.
That point of maintainability is raised and a question of jurisdiction is an issue. Then the courts will first decide that before deciding on anything. This is as opposed to, my lord, 749.
That's section 49.
This is slightly wider because I'm grateful because 49 is of jurisdiction.
Yes.
This judgment is specifically on jurisdiction because with regard to 711, there's both ways. There's
Yes.
both ways because 11A to D, it can cut both ways for me. But jurisdiction, if it's an issue, it's a very, very short judgment, you know, Justice.
Yes.
Kindly have a look at paragraph 3.
Yes.
Oh, sorry. 2000, a copy 2002 10 SEC, page 101.
But are you saying the court does not have jurisdiction, or are you saying that the award is not enforceable?
But I'm saying a award is not enforceable. So that this, because of a lack of jurisdiction, it does not partake the character of a decree. Its unenforceability is an issue.
Yes.
So the court's jurisdiction to turn it into a deemed decree, it has to satisfy the test of 48 for it to partake the character of a decree under 49.
Yes, but then how does 3 help you?
Because of jurisdictional issues, Milan.
Yes, so here the point was of jurisdiction.
Here my point is also not with regard to court's jurisdiction.
Yes.
I'm saying the enforceability of the award.
Yes.
2 and 3. The appellant has taken that for court has no jurisdiction to enter and decide the matter. High Court on its original side held the question relating to jurisdiction shall be decided at the hearing of the suit. Similarly, my lord, at Mr. Ghosh's behest, your lordship today will have to return a finding that I will hear this later pending this without recording a satisfaction as to executability. I'm going ahead and passing an injunction. That lordship will test my understanding on that. First, this is on that, on 49. Secondly, with regard to his abject, unexplained delay between 18 to 21.
Yes.
Then again from 21 to 23. And why he can't.
Why 21 to 23?
21 is when he filed the execution application. We are in October 2023.
Yes.
And I am addressing the court on the point of jurisdiction. And it's not correct to say, well, I understand that he doesn't hear my arguments, but I have referred to Customs Act provisions and all. Maybe it's not worth it for him, but I have referred to provisions and I've indicated, I've referred to judgments, which I've relied on a judgment that has come from this court, but it's still a judgment.
Yes, thankfully not this court, from the Supreme Court.
From Supreme Court.
Yes.
These are my respectful sense.
Yes, Mr. Ghosh.
Need 2 minutes on my response. Firstly, my lord, as my learned senior friend had already indicated, that the prayer for the affidavit of assets was made and was not entertained. Similarly, prayers for injunctions were made, which were not granted. It does not refrain the coordinate bench subsequently to grant an order of injunction. 1. 2, my lord, if it's passed, I can show orders, but the application was pending before this honorable court, and there's a lack of, and it was during the pendency of this application, there was the COVID situation. From 2021 to 2022, there was only one order which was passed. It's not that I did not attempt to have
And what
this
about
matter heard.
2018 to 2021?
My lord, it was not filed. we were deliberating, trying to get the matter resolved, my lord. It was not resolved. We came up and, my lord, we gave them notice immediately because
Mr.
order 21,
Banerjee, please.
order 21, rule 22 would be attracted. So we put them on notice and moved the execution application. Now, with regards to the, my lord, grant of an interim relief, my lord, the Fierce D. Lawson 2001 Supreme Court,
Yes,
it is
yes.
very clear. Execution and enforceability are not separate proceedings. So, my lord, this submission before this honorable court that enforceability first has to be adjudicated upon, only then it can be executed, is not the correct law, my lord. Fierce D. Lawson specifically lays down execution can be granted and enforceability need not be separately decided. My lord, we are in the stage of execution. 47 has been complied with. My lord, the satisfaction, if your lordship is pleased to record, it is entirely, my lord, a case where, my lord, the execution can proceed with. Maintainability, be that as it may, as he has raised the point, but that would not refrain, my lord, the court from passing an order protecting my rights and interests. Like, end of the day, what should be
Fierce D.
considered?
Lawson just brings those two proceedings together.
Yes. The
In-
court, my lord, the 2020 judgment, Vedanta has considered Fierce D. Lawson, but it has not taken a distinctive view that Fierce D. Lawson is not correct law. And it has not been distinguished. Apropos, my lord, the relief that I'm praying for today, my lord, my learned friend should also make this very clear. He is a judgment debtor today. So, my lord, his rights of an equitable jurisdiction, and because I have come in at a delayed stage, he does not stand in his mouth to, my lord, come up and make these submissions before court that he is not going to secure my claim because he has raised an issue of maintainability. My claim has to be secured. Otherwise, my lord, the entire process of execution should be rendered redundant. That cannot be. I am an award holder. Award, may lord, good, bad, indifferent. He has not exercised his right of challenging the award before the appropriate tribunal. He has not exercised his right of challenging or taking up these
Very well.
points.
I've
before the
understood.
tribunal.
Just one line on Fierce D. Lawson, Mr. Banerjee.
Well, it's considered, it's different with regard to 47, 48 and 49. And well, this is not the right law that because I've not preferred and challenged to that award, I'm not entitled to question the enforceability here. It's subversive of every judgment that
No,
both of
no,
us
that's
would
not
have
the
read.
point. The point is whether you suffer an injunction or not.
And one more, factually, my lord, nothing, no settlement from 18 to 21. We were never reached out. They never reached out to us saying, please settle. So that's possibly not correct factually. There are no averments to that effect also.
Very
There's
well,
no
very well.
averment before
Yes.
the court.
Yes, heard learned counsel appearing for the award holder and the award debtor stop list this matter on 19th October 2023 under the heading for orders.
Great, great.
Yes, call on that passed over matter, please. Mr. Mukherjee, which matter are you waiting for? 36. I will have to dictate an order before that. Or you don't have to wait. I will take it up on Thursday because I don't think we will reach 36. 30 last কোনটা হচ্ছিল? $29. Yes, you can come back on the next day. 36. Very well. Yes, if it's called on.
For orders matter, item number 9, Mrs. Krita Engineering.
Last order গুলো দাও তো একটু। Order গুলো, order। অর্ডারের ফাইলটা কোথায়? Mr. Sen was appearing.
Mr. Sen was appearing this much.
This is an application under section 11 of the 1996 Act. Stop. The underlying, the governing contract, the arbitration agreement is embedded in 4 work orders issued by the respondent to the petitioner for what was the work for? For কি বললাম for for storing, handling and shifting goods, materials supplied by the respondent to the petitioner. Stop. The work orders are the work was essentially for the purpose of installation of a HDPE capitals product pipeline for construction of sewer network in Mapusa, Goa and the North Coastal Belt. Stop. The estimated value of the work was approximately rupees 10.31 crores. And the arbitration clause was part of the was in the general conditions of contract which was made applicable to the 4 work orders. Stop. Next, the work orders were dated work orders are dated 24th December 2012, 26 February 2014, 1st August 2014, and 20th May 2015. Stop. Each of the work orders contain separate arbitration clauses. Stop. Next. There were 2 amendments made to the work orders, to the work order dated 24 December 2012, on 17th July 2013, and on 26th July 2013. Stop. The petitioner, the claim of the petitioner arises out of the unpaid invoices raised by the petitioner on the respondent stop the letters of addressed by the petitioner to the respondent on various dates from 18th February 2020 to 27th February 2020 to 27th February 2021. Uh, 27th February, what is the date of the work order at page 112? To 27th February 2020 are on record. Stop. The fact that the parties held at least 2 meetings on 20th February 2020 and 21st February 2020 are also admitted and are part of records. Stop. The meetings were for were with regard to the petitioner's demand on the respondent in terms of unpaid dues. Stop. The claim, the petitioner's claim is now approximately rupees 8.52 crores. Stop. The petitioner invoked the notice of arbitration. The petitioner invoked the arbitration clause on 22nd March 2023. Stop. The notice of invocation refers to all 4 work orders and the fact that the petitioner has performed the work and that the respondent has also made part payments under the 4 work orders, but failed to clear the outstanding dues of about outstanding dues amounting to rupees 8.52 crores, approximately rupees 8.52 crores. Stop. The respondent did not reply to the notice of invocation. Stop. Next. The only point which is before the court, comma, as argued by learned counsel appearing for the parties, comma, is whether the 4 work orders are to be seen as separate arbitration agreements necessitating 4 separate references, or whether the petitioner can or is entitled to consolidate the 4 work orders in terms of a single notice of invocation and a reference. Stop. Next. The from the material disclosed to the court, comma, it is evident that the part payments made by the respondent in favor of the petitioner was not made in terms of individual work orders, but consolidated payments from time to time. Stop. The respondent has not produced any document to show that the respondent at any the respondent treated the work orders to be separate arbitration agreements or made the payments in accordance with the invoices raised under the separate work orders. Stop. The respondent also did not take this point as a rebuttal to the contents of the invocation notice. Semicolon, the respondent did not reply to the invocation notice at all. Stop. এইটা ছাড়া আরেকটা জাজমেন্ট দিয়েছিল বার করো এখানে আছে next a similar point was considered by the court in two other matters, namely in SMT stop Bharati Ojha versus Simplex Infrastructures, AP 492 of 2023, and Sanjoy, SANJY, Sanjoy Mojumdar versus Regent Hirise, AP 352 of 2023, where the respondents in those cases had also urged the point of separate work orders. Stop. The court, however, relied on the the connected nature of the work orders and the composite and the fact of the work orders being issued in respect of a single project and decided the maintainability point against the respondents. Stop. The court relied on Amit Lalchand Shah to hold that the different work orders pertain to a single commercial project and all the work orders within brackets agreements in those cases, close brackets, were interconnected. Stop. Next, in the present case, comma, all the four work orders relate to the installation, relate to the work of installation of HDPE product pipeline and construction of the sewerage network in Mapusa and the North Coastal Belt, comma, the work orders were issued. The respondent issued the work orders on the petitioner for execution of the work for this single project. Stop. Hence, comma, the respondent's argument of the four work orders having independent lives or purpose is not acceptable. Stop. The Supreme Court decision in Amit Lalchand Shah 2018-15 SCC 678 would squarely be applicable to the facts of the present case. Stop. Next, considering the fact that the petitioner's grievance of unpaid dues and the respondent's inaction to satisfy the petitioner's claim is a dispute, comma, this court is inclined to allow and dispose of the application as the disputes are directly relatable to the arbitration agreements, and the petitioner can certainly make a consolidated reference of all the 4 work orders in its notice of arbitration, in its notice of invocation. Stop. What is the claim?
Is approximately, my lord. I'll just take a minute, my lord.
5.68.
5.6. Yes, 5.6.
Not 5.68, 8.5. 8.52, not 5.68. Next, AP 489 of 2023 is accordingly allowed and disposed of by appointing blank. Paragraph order to be communicated by 19th October 2023.
So your lordship wanted to know the date of the document at page 112. That's my lord, 27th February 2020.
Very well, thank you. Call on the 1 o'clock matter, please. Yes.
I have liberty to mention item 37, lord.
Are you traveling from outside?
Yes,
From where?
from Delhi.
Delhi.
This is an
37 is
execution
what? 37 is?
This is an execution application. We have a 731 crore award in our favor.
You're the respondent.
Yes, my lord, we have taken out an application with regards to the maintainability of the execution application.
Are you traveling back today?
Yes.
Very well, you come back at 2. Call on the 1
Lord,
o'clock
only,
matter, please.
one indulgence, my lord. I'm led by Mr. Singhvi, my lord. He was requesting if it could be either on the November 23 or 30.
Ladyship may have it on 23rd November. If it's
23rd November. You're not, you're fine with not pressing the application? Yes, it's 37 to Dakoto. You're traveling back today. You're returning today, 37 to Dakoto.
Item number 37, the Federal Agency for State.
Yes,
Forward
yes,
Management.
yes.
I have taken out an application with regards to the maintainability of.
Yes, when do I put this matter? Tell me,
ladyship,
when do I put this matter?
ladyship may have it on 23rd.
23rd, mention a month at least.
23rd November.
Yes, list this matter on 23rd November 2023 as
Ladyship,
per.
may I just make another additional request if it's convenient to the court, ladyship, if it could be slightly higher up on board, ladyship.
Very well. It's what, a foreign award?
Yes, yeah, international domestic award.
International domestic award, what does that mean?
731 crores, ladyship.
Very well. I'm asking you what kind of award. I'm not asking for the quantum of the award, please. And figures don't make any difference to this court. Please, yes, call on the 1 o'clock matter, please.
Like
1 PM matters, item number 6 and 8. Hindustan Aegis LPG Limited.
my lord,
For the accommodation.
Mr. Yes, just stand up. and look.
Just one minute, regarding the 5-minute submissions which I made yesterday. My lord, there is one correction I like to make, and I've indicated that in my notes also. My lord remembers there is a twin arm which has got damaged at HOJ
One arm
one.
has got damaged.
My lord, that's what I wanted to say. I've given a sketch in my affidavit in opposition showing that Indorama has one arm. Hindustan has 2 arms. Haldia has 1 arm, and Indian Oil Corporation has 2 arms.
I thought,
No, my lord,
not a total of 10, no.
No, yes. Now, my lord, what I am talking about, the 2 arms of Hindustan is a twin arm. And Indian Oil Corporation is also a twin arm. What is a twin arm? A twin arm is with the 1 arm, you are doing both unloading. And it's joined with another arm, you are also doing unloading. Whereas my lord, Indorama or Haldia has 1 arm, means it's a separate loading and a separate unloading.
So what is the point?
The
Mr.
point
Bose?
which I am saying, my lord, their case is that in HOJ2, there is also another twin arm, which is doing twice loading, unloading, and from the other one is also loading, unloading. Now, I said that the HOJ, yesterday that HOJ1, because of the alignment of the two sets of arms, both are destroyed. I said one is no. HOJ2, the two arms, two sets of twin arms are operating. So, my lord, in HOJ2, two vessels can
So
come in.
what is destroyed?
The twin arm at HOJ1 is destroyed, which means that in HOJ2, my lord, this is what I wanted. The twin arm is there. So simultaneous two loading, unloading.
Very well. Mr. Bose,
Yes.
what is
I have
the,
indicated in the note.
what is the, how does this, this gas, fluid, liquid, how does this have a bearing on your prayer for reduction of security?
My lord, the fluid and gas
Apart from whether there may have been incorrect
on the
statements in the claim.
duty of care,
Yes.
and I've indicated on the duty of care,
Yes.
it proceeds as if on the basis that I was discharging for their entity, Hindustan. That is on the duty of care, it has the basis.
Yes.
Only on that point. My lord, I've indicated best of my ability, whatever I wanted.
Best arguable case.
Best argue, reason, no. Reasonably best arguable case. That's the expression. And please have a look at the learned single judge, Justice Sriram's judgment on this point. It has been explained. I have quoted it.
Justice Shriram keeps on sending me his judgments, but I don't remember this one. Because
Well,
this I
My
don't
lord,
know.
Justice
Yes.
Sriram, your lordship may not know, was Admiralty judge
No,
for a
that
long
told
time.
me, that
and-
he's told me many times.
And my lord, he was in his chamber of Mr. Ribello. My lord.
Mr. S. Venkataraman.
Venkataraman, yes, and he came down once, you remember. He was very, very knowledgeable, I must say. Mr. Venkataraman, he and Prashant Pratap, they were the three combination. And ultimately, Justice Pratap's son, he did not get elevated.
Yes. No, he's actually quite a
Very
very
knowledgeable
good and a very good friend. So He's-
Just
he's-
have a look at Milord,
yes,
entire case on reduction of damages, the way he has done it.
yes.
I could have easily cited, my lord, another of Justice Sriram's judgment on tort and where he has cited. Unfortunately, because it is the subject matter of appeal for the last 11 years, I did not cite.
Yes.
Otherwise, it would be squarely applicable.
Very well.
That
Yes,
case, there was
Mr.
no physical damage. I know the judgment which Mr. Bose is talking of. There was
Yes.
no physical damage. It was a case of pollution. Anyway, that is neither here nor there, my lord. The installation at HOJ1 has been
Yes.
completely damaged.
Yes.
That is why I have claimed only half of my income
Correct,
because
correct.
HOJ2 is functional. The
Yes.
vessels which call at HOJ1, I cannot handle.
Correct.
So I lose my revenue from there. They will go to my competitors, which is in petroleum, the other entities which are there.
Correct.
That is the basis of my claim.
My lord, I have
There's
said
nothing
that.
in
I've dealt with that in my.
HOJ1 is completely inoperative.
Yes. We are not exchanging. As usual, my lord.
No, I can exchange. I have
No,
exchange.
I can, if you want, I can. My lord, let us exchange, my lord, just in case. We are exchanging.
You don't need the court's leave. You do whatever you want.
No, they'll say,
Well, Mr. Bose's font size is smaller than mine.
my lord, just to, my lord, his pages are bigger. His pages are bigger.
Legal size,
My
not
lord, just
custom
trying
made.
to say, because your lordship fixed it at 2 pages, now he has, look at the page. My lord, now this will be equivalent to 7 pages.
No, he did say that in the
Yes,
morning.
sir, it
That
was
that
7,
is
I
7.
got it down to a reasonable 4.
Mr. Thakkar, take back the note. Increase the margin. I just can't read.
Sorry, I'll increase.
I can't read.
Well, the spacing of the
My lord, is your lordship referring to
This
mine?
bill has to also.
No, no, no. Mr.
Mr.
Thakkar,
Bose is perhaps also.
yours is fine.
Mr. Bose,
I just can't read.
I'll increase this.
No, 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 that's yours.
ওটা ওনার আছে,
My-
ওনারটা ছোট আছে।
মেলা দেন করে বেশি করে যেটা ছিল বেশি পায়।
Your lordship has had, kindly take a look at mine, my lord, if any modification is required, I'll
And
request
your
it.
to is I mean,
Legal size.
No, yours is fine.
now we'll do legal. Now this is.
Very well. But Mr. Bose,
Manner we'll give it.
Yes,
But please keep it. Please keep it. We'll better font size. I mean, we'll
yes, yes.
just after this. I mean, during the luncheon.
Yes, yes. Please do it and give it by 2,
Have you understood? Huh? Never take it.
because otherwise I won't get time to read.
No, no.
Yes, learned counsel appearing for the plaintiff and the defendant owner. You're one, Mr. Bose, one. And the defendant owner has handed up their respective notes. Stop list this matter on 19th October 2023 under the heading for orders. And have you indicated, Mr. Bose, what I asked you yesterday as to the reduction?
I'm only asking Mr. Thakkar. We have the habit of in the defendant writing. I also started it. IMO something. Owners and parties interested in empty pollux, then IMO. I mean something. I mean, where did I also did it. But
What does
IMO, what
IMO
that-
mean?
I want to know him.
What is IMO?
My lord, IMO is like the vessel number, the registration number of the vessel with the International Maritime Organization.
Right. So
It's
why
not
do you have to
required.
indicate this?
It's like the
I mean, in a
address or
cost
the
type.
identification of the vessel. It's not required.
No, I saw it in some other.
Every time we just copy IMO
Yes, yes,
something.
other, yesterday there was an order of arrest or maybe day before, I've now forgotten. Again, IMO, I in fact asked, who was it? Mr. Shodaru Banerjee. That
IMO is
what does this mean?
International Maritime,
Oh,
this is the particular
Well, I did
number.
took advice. That old matter which was pending, I remember now. Oh.
No, this
Yes,
is
yes,
some vessel in,
Oh,
Andhra-
no,
in
it was
Port Bay.
Andamans.
Yes, yes. Old cause of action, it got dismissed. I remember.
Mr. Bose, you better tell Mr. Banerjee that you've said all these.
No, IMO, because no one knows. Oh, I find it
That
very
while
amusing.
he was having his lunch, you have effectively destroyed
His case.
his case. You
For not
better go
having
and tell him.
engaged him in the matter.
No, I was, they cannot.
Yes, yes. Very well, yes.
Grateful, my lord. You too.
Hello. I'm mentioning the item number 6 and 8 in which we had to submit a note. There was some
Call on
typography.
the list, please.
Non-commercial matter, item number 1, to be mentioned, Mickey Metals Limited.
I appear for the petitioner, my lord. The section 11 application, my lord, AP 403 of 23 was disposed of by your lordship, my lord, by an order dated 18 July 2023.
Microphone, please. Yes,
18 July 2023. May I hand over a compilation, my lord, of the orders and communications?
yes.
My lord, subsequently, we communicated the order, my lord, by way of a letter dated 20th.
Yes,
Lord, we communicated the order, my lord, to the learned arbitrators who appointed on 20th of July 2023.
yes.
Thereafter, although there was no communication, my lord, we did not receive any response. Subsequently, on 30th of August, we again wrote to the arbitrator for fixing the first date. My lord, thereafter, also there was no response. So, my lord, by a letter dated 29th of September 2023, we requested the registrar, original side, to, my lord, inform whether the consent has been received or not from the arbitrator. My lord, by a communication,
Very well. So what do you want?
my lord, any other person may be appointed as an arbitrator. My lord, that is all.
Yes, learned counsel appearing for the petitioner. Excuse me. Relies on an order passed by this court on 18 July 2023, appointing blank, page 2 of the order, as the arbitrator to resolve the disputes and differences between the parties, and a series of communications thereafter made to the learned arbitrator on 20th July 2023, 30th August 2023, 29th September 20th July 2023 and 30th August 2023 to the learned arbitrator, communicating the order passed by this, communicating her of the appointment, communicating the fact of appointment to the learned arbitrator. Stop. Next, the petitioner also wrote to the registrar, original side of this court, on 29 September 2023. Stating that seeking to find out whether the arbitrator had communicated her consent in the prescribed format to the registrar, original side. The registrar's reply dated 6th October 2023, stating that the arbitrator has not reverted with her consent, is also placed before the court. Stop. Next. Since the learned arbitrator who was appointed by the order dated 18 July 2023 has not communicated her consent, despite 3 months having gone by from the said date of the said order, from the said order, comma, blank is appointed in place and stead of the previous appointment. Stop. The other parts of the order shall remain unchanged. Stop. The learned arbitrator, the newly appointed arbitrator will communicate his/her consent within 3 weeks from the date of communication within 3 weeks from 19th October 2023 in the prescribed format under the Act and under the 1996 Act and the schedules. Stop. The petitioner shall communicate this order on the learned arbitrator by tomorrow. Stop.
To Unlimited. My lord, my application under section 11 of the Arbitration and Conciliation Act, my lord, an agreement was entered into by and between.
Are you disputing?
Yes, my lord.
What is, you're saying there's no dispute?
My lord,
Microphone.
My lord, in the arbitration agreement,
Can't hear you.
my lord, in the arbitration agreement, in page 35, point 23,
I can't hear you. Learn to use a microphone, please. Yes.
page 35, point 23, it stated that any
Yes.
it stated that any different dispute or differences whatsoever arising between the parties out of or relating to the construction, meaning scope, operation, or effect of this contract, or the validity or the breach, which cannot be resolved through negotiations within a period of 45 days, my lord. So this they haven't, the mediation has
Very
not.
well. Yes. Yes. What do
Your
you have to say?
lordship, my lord, would kindly consider, my lord, the letter, my lord, at page 82, which is, my lord, the request for appointment of arbitrator. My lord, this is
So
the
where
notice,
is your invocation notice?
my lord, page 82, my lord.
Yes.
Your lordship would kindly see, my lord, the subject is request for appointment of an arbitrator. My lord, the third last paragraph is important, my lord. As against conversion job done by us, we raise various invoices upon you for a
Did you
total value.
understand the point taken by your learned friend?
My
Your
lord,
learned friend is saying that you have not exhausted the negotiation conciliation option in the arbitration agreement.
your lordship would kindly,
45 days is given for that. Have you exhausted that?
my lord, that has not been done, but what has been done, my lord, is several requests and reminders were made, my lord. Disputes had arisen, my lord, no payments.
So show me a letter saying that we want to exhaust that option of 45 days.
My lord, your lordship would kindly consider the letters, my lord. If your lordship kindly sees page 71.
Very well. Says that cannot be resolved through negotiations within a period of 45 days of the notification of such claims. Yes, when is the first or the last claim given to the respondent?
My lord, the first claim was given, my lord, on 6th of April 2023, which is appearing at page 71, and the last of which is, my lord, at page 82, the letter, my lord, which I was placing before your lordship.
My lord,
Yes. So show me that 45 days you have waited and then for the negotiation, or at least the first part of the arbitration agreement, and then it could not be worked out.
My lord, your lordship would kindly consider page 64. That is my first.
Yes.
Your lordship, with non-payment of dues of my client.
64. You said page 71.
71 is the demand, my lord.
Yes.
The demand. Your
Yes.
lordship would kindly come at page 64 once.
Yes.
Well, in terms of the contract executed by and between yourselves and my client above named, from time to time, my client supplied you coke after conversion of coking coal supplied to you. After execution of the conversion job, from time to time, my client raised various invoices upon you for a total value of rupees such and such, out of which you have released a total payment of such and such, leaving behind such and such, and credit note amount of rupees such and such. A sum
Don't
is still,
place the letter. What is the point?
my lord, I had, my lord, by these letters sought for releasing of my dues. My lord, per se, my lord, that a dispute resolution is required, or I want to enter into it, my lord, in unequivocal terms, my lord, is not there, my lord. But in any event, your lordship would kindly consider that from 25th of January 2023, my lord, several occasions where, my lord, I had been, my lord, saying to kindly, my lord, make payment of dues. The dues are admitted by them.
Yes. Where are your other letters? After
Hello?
page 64, then 71. Then,
My lord, then, my lord, the next letter is at non-payment of dues for an indefinite time is at page 67 also.
give me the date, please.
Yes, my lord. My lord, page 67 is 14th of February 2023. Then, my lord, your lordship, the next letter is at page 69 dated 6th of March 2023.
Yes.
A reminder email of 6th of April 2023 at page 71. my lord, page 74, a letter dated 20th May 2023.
Yes. These are all demand letters.
My lord, seeking the payment due, my lord.
Yes.
And my lord, finally, your lordship, my lord, the letter at page 82, my lord, which is, my lord, suggesting a name for the learned arbitrator, my lord, which appears, your lordship, at page 84, my lord. My lord, this letter was received by them, my lord. No response thereto.
My lord, we have replied to the
You
section.
will speak only when I ask you to. All right. Yes. Yes. Anything else?
My lord, disputes have arisen between the parties, my lord. There is an arbitration clause not disputed by my lord.
What is your claim now?
My lord, the claim now, my lord, as it appears from the section 21 notice, is in excess of, my lord, 1 crore.
And they have not replied to your invocation notice. Yes.
My lord, we have,
Microphone, please.
my lord, we have replied to the section 21 notice
There
on-
you have. When?
on
Where?
July 21, 2023. For this, my lord, I have to file my affidavit in opposition. my
Why
lord.
have you not
My lord,
disclosed that?
my
lord,
instructions, my lord, are we have not received, my lord. If my learned friend can show a proof of receipt, my lord.
Yes. Give me a
My
copy.
learned
of the letter.
advocate is.
Show me a copy of that letter. What is wrong with you? You are ESL and this is by Vedanta. Yes.
Yes, my lord, I'm representing ESL, my lord.
But this letter is from Vedanta. That's what I'm asking you.
My lord, I shall take up the instruction regarding this letter.
You're the advocate on record or counsel?
My lord, yesterday only we have received this brief and I undertake to file my wakalatnama as well. And my instruction is to file affidavit in opposition, my lord.
Are you the advocate on record or counsel?
No, my lord, not yet. I'm not.
You're neither.
My lord, advocate on record, my lord, I'll undertake to file my wakalatnama.
Can't you understand the court's question? Are you the counsel or the advocate on record?
Advocate on record.
So you can't understand English. What is the problem? 5 times I have to ask you. And you should have said that at the right at the beginning, that you received it only yesterday or whatever, and I would have given you time. You're taking up points of arguments. You don't even have a right of audience because you haven't filed your wakalatnama. You should have said that to the court. Yes. The advocate on record of the, what is your name?
Mandeep Kaur.
MS Mandeep Kaur. DIP or DEEP? Mandeep Kaur, DEEP, comma, who seeks to represent the respondent, comma, will file the wakalatnama in the course of the day. Stop list this matter tomorrow. Don't waste the court's time, please. The court is under a huge amount of pressure. Please don't do that ever.
The affidavit of service we kept on record.
The affidavit of service is kept on record. Next.
Item number 3, Dinesh Infra Projects Private Limited.
My application under section 11. Lord, the dispute arise out of a tender with Damodar Valley Corporation. I am the service provider.
Section 11.
Section 11. My lord, the notice inviting tender was of 2019. My lord, thereafter.
Are you disputing that?
No, my lord. So far the
microphone,
before,
please.
My lord, before invoking arbitration jurisdiction, there is a provisions, my lords, for appointment of adjudicator, my lord. That
adjudicator. Show me the arbitration
Yes,
clause.
my lord. I invite your lordship's attentions at page 118 of the work order. Because no agreement was executed. 17.
No, so the arbitration clause is embedded in the work order.
Embedded in the work.
118.
118.
Yes.
Clause 7.0. Settlement of dispute and arbitrations as per clause 33 and clause number 20 optional terms and conditions of contract of GCC 2016. Clause number 20, my lord, at page 102.
What is GCC 2016? You're the railways.
General conditions of contract.
Yeah.
Who are you? You're the
Damodar
railways.
Valley
Damodar Valley Court.
Yes. And where is that? Page 30?
Page 102. This is the
102.
optional terms. Clause 20. Clause 20.1. If any dispute of any kind whatsoever shall arise between the employer and the contractor in connections with or arising out of the contract, including without prejudice to the generality of the foregoing, any question regarding its existence, validity or termination, or the executions of the facilities, whether during the progress of the facilities or after their completions, and whether
This is not relevant. Place the relevant
no,
part,
that is
please.
present below, 20.1.2.
Yes.
Adjudicator, no, below 20.1, last three lines, my lord. If the parties fail to resolve such a dispute of difference by mutual consultation, then the dispute shall be referred in writing by either party to the adjudicator.
Who is the adjudicator?
Adjudicator, my lords, my lord, may be appointed by your lordship, my lord.
Adjudicator? No, the
Adjudicator.
GCC doesn't provide for it.
No,
What will be
GCC, my lord,
appointed by this court will only appoint the arbitrator, not
no, my lord,
adjudicator.
there is two clause, my lord. Just chairman, my lord. Chairman has to appoint.
I can't hear you.
Chairman has to appoint adjudicator.
Show me the clause.
Yes. The adjudicator shall give its decisions in writing to both the parties.
That is not
That so far
relevant.
yes, my lord, that so far the appointment of the adjudicator is concerned, my lord, there is no provisions, my lord.
So who will appoint the
My
adjudicator?
lord, there is.
There-
My lord kindly takes 20.1.3
1.3, yes, yes.
towards
yes,
the
my lord,
middle,
yes,
failing
yes,
agreement between the two.
Yes.
Has your lordship got it?
Yes.
Failing agreement between the two within 28 days, the new retired judge of High Court, Supreme Court of India shall be appointed as that.
No, if he fails, first
Wait. Wait, you finished, you're done.
Yes.
Yes,
Not on this.
yes.
My lord kindly takes the work order, if your lordship can,
Yes.
page 118. My lord, there are two clauses. 118.
Yes.
My lord, settlement of disputes and arbitration as per clause 33 and clause 20, which is optional terms. My learned senior friend is referring to the optional terms. I am referring to the compulsory terms. My lord, compulsory terms, which is clause 33. It is at page 93.
93.
Yes. My lord, point number, clause number 33. Settlement of disputes. My lord, the first proviso is for amicable settlement. If that fails, then arbitration. There is no other dispute with
Yes.
regard
So
to
have you
this.
exhausted this amicable settlement?
Yes,
You have.
my lord, I have sent letters right from June 2020 till December 2021. Not a single reply. They have replied
Yes.
only.
Show me those letters.
Yes, my lord, starts from page 160. My lord may not be troubled with those letters. 160, 162, 164, 173, 180, 193, 2010, 210. My lord, my last demand was in 24 February. Demand for this particular dispute which arises. My lord, those are, my lord, parts, bits and pieces of the disputes. My lord, those have been aggregated and made composite in the demand notice at page 246, which rounds up to a figure of 1.05 crores dated 24 February 2023 at page 246. This is the demand notice. Volume 2.
Yes.
Page 246.
So this is your invocation as well, or just?
No. My
Yes.
section 21 notice is at page 256.
Yes.
No reply to either of the demand notice or the invocation notice.
Yes.
So there is no dispute with regard to the existence of arbitration clause, and there is no reply to this demand notice or the section 21 notice.
No. But the arbitration clause which you showed me,
Yes.
showed the court,
Yes.
says that first there will be
Settlement of disputes amicably.
yes.
My lord, I tried to through all those letters. There was no.
Yes, but this letter doesn't talk about any settlement of disputes amicably.
My lord, this particular letter does not, but all those letters right from 20.
Show me.
My lord, I had written and indicated not specifically with regard to amicable settlement, but I have raised these issues, they have not replied.
So show me a document that you wanted to exhaust this option.
My lord, page, right from page 160. Now, this is firstly a mail which says that the site has not been provided. I have
Doesn't say anything about amicable settlement.
Yes.
Yes.
Page 162.
Yes.
This is with regard to the referred work.
Doesn't say anything about amicable settlement. Next.
1664.
Nothing. Next.
173. (180) thereafter.
Show me one letter, Mr. Datta, which talks about amicable settlement.
But I are not on clear terms.
Very well. So exhaust that and come back. Yes. The arbitration agreement, the settlement of disputes and arbitration clause containing the arbitration agreement at clause 20.1 of the GCC. No, what is this? Works and Procurement Manual.
This is GCC.
Of the GCC/Works and Procurement, GCC contained in the Works and Procurement Manual, July 2016, of the petitioner, comma, provides for the parties first making an attempt to resolve their disputes or differences by mutual consultation. No.
Amicable.
No, at clause 33. At clause 33 of the general conditions of contract, at clause 33 of general conditions of contract, provides for amicable settlement between the parties of any dispute or difference which may arise out of the contract. Stop. It is only after failure of the amicable settlement that the dispute will be referred to the chairman of DVC or a person nominated by him for arbitration. Stop. Next, the legality of the unilateral appointment by DVC is not an issue here, semicolon. The only, the court has been called upon to decide whether the petitioner's application under Section 11 of the 1996 Act can be allowed. Stop. Next, the arbitration clause, the arbitration agreement at clause 33 provides for the parties first making an effort to amicably resolve the disputes. Stop. None of the series of letters disclosed by the petitioner and placed before the court refer to any such amicable settlement. Stop. Hence, comma, the petitioner will first have to exhaust the pre-arbitration condition before the petitioner can seek appointment of an arbitrator. Stop. Next, AP 707 of 2023 is accordingly disposed of in terms of the above.
Affidavit of service.
The affidavit of service is kept on record.
Item number 4, BGM and MRPL GM City.
My lord, I appear on behalf of the petitioner, may it please your lordship. My lord, this matter is an application under section 11 of Arbitration Conciliation Act. My lord, this matter was filed under, my lord, commercial division, but my lord, the matter is appearing in the non-commercial list of your lordship, my lord.
You filed in the commercial division?
My lord.
Yes, Mr. Arifin.
My lord, I have already sent. I have already sent.
The ECL has not received the copy.
I can't understand what you're saying.
But I am appealing for receipt authorities, my lord. We have not been served with a copy, my lord.
My lord, I have, copy was already sent, my lord.
So very well, what is it that you want? Why should it be commercial division?
But it's arising out of a notice inviting tender in which, my lord, the petitioner participated, and dispute is arising out of a contract, my lord, in regard to, my lord, excavation of coal. And my lord, subsequently, my lord, after arising of the dispute, my lord, section 9 was also preferred in the commercial court of Asansol, my lord. It's a commercial dispute in regard to commercial dispute. That's why, my lord, the section 11 application
Just
also
you're
filed.
saying that won't make it a commercial dispute. How is it a commercial dispute?
My lord, the subject matter of the dispute is a commercial contract.
Very well. There appears to be a mistake in the listing of the present matter. Stop. The application, the AP was filed in the commercial division. Stop. The matter shall accordingly be transferred to the commercial division, and the department shall take necessary steps. Stop. Department shall take necessary steps. Let the matter be listed. When do you want to move it?
My lord,
Just give us a
as convenient to your lordship, my lord. I'm leaving.
Tell me a date. Before the vacation or after the
My lord,
vacation?
before vacation.
List the matter on, let the matter appear in the list tomorrow.
My lord, I will hand over a copy.
Do it right now.
I'm grateful to your lordship.
Mr. Ghosh, please tell the concerned person that without a gown, he has to sit, he has to stand behind.
That
Item number 528. In the matter of Dunlop India
my
Limited.
application. My lord, yesterday lordship was pleased to take up, and lordship has directed the official liquidator.
Please, you will speak only when I ask you to. Yes.
My lord, we intend to purchase 50. My lord, yesterday lordship was pleased to take up this matter, my lord. My lord, I appear
Where
on
is the official liquidator?
My lord,
I'm praying for unqualified apology, your lordship. Official liquidator is not well, your lordship. But I have the instruction, your lordship, and the assistant official liquidator is also present before your lordship. But yesterday afternoon, I didn't have the instruction at that point of time when the
You should have been on the online virtual mode. If he's not well.
Lordship, that instruction I have received few minutes back, your lordship. So
Few days back means?
Few minutes back, your lordship. But I have the instruction, your lordship, and my lord, but he's not
10
well.
minutes. Ask him to appear on the virtual mode. 10 minutes. It's a direction of the court.
Lordship,
He will be hauled up from his bed, wherever he is.
Lordship, I have
10 minutes on the virtual mode. Next.
Item number 6 is a different matter, my lord.
Item number 6.
Yes.
I for the official liquidator opposite.
I pay for in item 6 on behalf of the applicant, my lord. He's a former workman, my lord. This is the matter which Mr. Jishnu Chaudhary had mentioned yesterday, your lordship.
Yes, yes.
Pursuant to your lordship's direction, my lord, on 20th November 2022, certain amount of dues were disbursed to the applicant, my lord, the former workmen's, my lord.
Yes, what was the last order passed?
My lord, this is, my lord. Order
Miss
dated,
Dashti, you're for the official liquidator?
Yes, my lord.
order dated 20th November
Where is
2022, which is at page 11 of your lordship. My lord, the order, if your lordship comes to page 20,
This was passed in which application?
well, in all the applications filed by the former workmen, some of the former workmen's, my lord, where
Yes, what is it that you're wanting now?
well, I'm praying for, my lord, disbursement of the remaining claims of
I
the
can't
workmen.
hear you, microphone.
Well, I'm praying for disbursement of the remaining claims of the workmen, my lord.
Yes, Ms. Dashti. what
Yes,
is
my
it?
lord. This applicant, your lordship, is the ex-workman of the Ambattur unit, Shahaganj unit. my lord.
How many are before the court?
This is
one.
only one, my lord.
Yes.
Now, it is an admitted fact that he has already received, pursuant to your lordship's order dated 20th November, your lordship, he has received his 50%. Now, your
20th
lordship,
November,
20th November 22, my lord.
he has received 50%.
Yes.
Which is how
Now,
much?
This is 60,000. It's there.
Page 23, my lord, I have annexed the bank statement, my lord, 60,500.
60,500 and the actual claim was 1,21,000, my lord. So he has received his 50% pursuant to your lordship's order. Now he is asking for the remaining balance. That cannot be paid now, your lordship. Because that the ceiling limit was 125, over and above, nobody will be paid. But the 50% of the
125
claim,
as in 1,25,000.
1,25,000.
Yes.
And now the 50%, all the workers will be getting 50% of their claims. But if the 50% of the claims is over and above 125, that they will not get, and that is the ceiling limit. And your lordship was pleased to observe
But
it in the order.
this claim is 1,21,000.
1,21,000.
Yes.
But he is supposed to get only 50%. That is the pursuant to your lordship's order, because on the if your lordship kindly takes up the order dated 20th November, that was the first order passed in all the applications filed by the workers of all the units, my lord, that the ceiling limit was 125, over and above, none of the workers will be paid. And if it is less than 125.
Show me the page, please, and the part.
Yes, my lord. I think so. They have not annexed the entire order. May I hand up a copy of the order, my lord?
Not the entire order. Page 2021, that's not the entire order.
No, my lord. It's the entire order. The page is missing in my.
For the last page.
No, এটা আমি আমার থেকে নিয়ে এসেছি। Internal page 10, my lord. It is made clear that 1.25 lakhs may not be the entire claim of the workers and will represent only part of the claim. This figure has been arrived at on the submission made on behalf of the official liquidator, and the official liquidator, as an interim measure, can entertain claims 50% of which do not exceed rupees 1.25 lakhs. In order to protect the individual worker and to prevent the money reaching the wrong hands, the official liquidator is directed to pay the amount to each individual worker of the two factories or to their surviving legal heirs upon production of the succession certificate, and the exercise of the payment should start on and from 12th December 22, liberty to apply.
Yes,
Now,
so
your lordship, he has
50%,
lodged his claim in a collective.
50% will not exceed rupees 1.25 lakhs.
Yes, my lord.
So here it's much
50%, 50% of the claim. That is the main issue, my lord.
Yes.
And if somebody's claim is over and above 125, but that will
His
not
claim
cross
is
125.
less than 1.25.
Maybe, but the
Yes.
50% of the claim, whatever be the claim, irrespective of the claims, that has to be 50%. And the ceiling limit is 1.25.
Yes.
So now
you have paid
50% has
everyone?
already been paid.
Yes, yes, Mr. Chaudhary.
This is, my lord, this application is, my lord, inspired by, my lord, I had a conversation with the official liquidator who told me that why don't you apply, we'll agree to pay, because we are in possession of funds, and if you apply to court, we can pay you more. So I've applied. Second part, my lord, is that
No, how does your demand fit in with the order passed by the court?
no, my lord, I'm praying for a further order.
Yes.
For ad hoc, my lord, payment. These people are, my lord, in dire state. It's
No, but Mr. Chaudhary, you're representing only one worker.
No, I'm actually representing.
It's not that you're representing a whole bunch of workers and they are
Yes,
they have come to the court.
Yes, all of them are there. I can file an application, my lord.
So aren't you representing only one?
No, I'm representing all of them. I was
What do
appointed
you mean by
by
all of them?
No,
How
no,
many?
no, no.
all
This
workers.
applications-
I was appointed by Justice Shonji Banerjee in his lordship's order.
I remember that, but how many workers are you representing?
This application is only one person has applied because it's very difficult to ask them to come. But I am actually praying for an order which is not across the board for all the workers. Official liquidator told me that I'm going to pay. If you apply to court, I'll agree to pay.
Yes.
For the sums. That's number one. Number two is, it's, my lord, been I think more than 12 or 13 years that these work, and they are the only people who need the money. They are the only people who need the money and they are the ones who haven't been paid.
No, Mr. Chaudhary, I can understand the sympathy part of the
Yes.
part of your submissions.
Legally,
But there's
my lord,
also a reality
yes.
as to how much money is available with the official liquidator.
That
So the
will not
court
be-
cannot pass random orders.
No, I understand, but official liquidator will agree.
No, I'm not agreeing to that because this is my
You may not
instruction.
agree,
No,
but
this
I
is a
want
written
to-
instruction
One
I've
minute, Mr.
received from
Dashti, I
the
will come
official
to you.
liquidator.
Yes, yes.
You know, the official liquidator himself had said at the NCLT that if you apply, I may agree.
When? Before he became unwell?
Before he became unwell, two weeks back. And since then, Lord, I've been trying to get this. I'm praying for an order which is, Lord, across the board. If he's become unwell today, Lord, if he recovers tomorrow, I can come tomorrow. I'm not on these one-page instructions. I am, Lord, on what the official, let him come and say that, no, I didn't tell you. And then, Lord, I'll fight it out. Then he'll have to file an affidavit disclosing what are the claims which he has received. He has to explain why he has not admitted or has not admitted some of the claims. He has to say why in 13 years he has not been able to settle a list of claims. He has to explain why in 13 years he has not been able to sell off properties. And he has to explain why, despite being appointed by the High Court, he is now roaming around in NCLT, getting appointments from the NCLT. The other day, he has no time to do this work. Why is he getting appointment in NCLT?
Appointments of what?
As liquidator. Very easy to come and say, well,
Unofficially.
officially, he is now, my lord, being appointed under the IBC by the NCLT. I'm shocked. He has no time to do this work. Most of it is outstanding. There has not been a single liquidation in 22 years that I have seen. And whenever you come to court, there'll be opposition. With two statements are not usually made. Number one is, I want to file a report. So that day, my lord, is gone. Next is, my lord, that I'm opposing any claim made. But why? You're my custodian. The
Official liquidator was appointed by who? Justice Sanjeev Banerjee.
In this matter?
Yes.
Yes, but my case has.
No, I just want to know by Justice Sanjeev Banerjee.
No, if your lordship looks at the history, this was
this particular official liquidator.
No, the office was appointed by Milord Justice Kollanjyoti Sengupta under section 450 initially. If I am
No,
not
so
mistaken.
this particular gentleman has been continuing since when? I'm asking you that.
I have no idea. Milord, I am only attacking the office. I have no personal prejudice against anybody.
No, the office is all about people who man the office. Yes.
I have, Milord, I am prejudiced because I have around 4,000-5,000 workers. Some are dying. They're in poverty. They don't have money. And Milord, over here, official liquidator for the last 13 years is playing games. And complete collusion with Pawan Ruia, the promoter, for Milord 13 years. The lordship has seen the other matter.
Very well. I have kept the other matter. Just 1 minute, please. Yes, yes, Ms. Dashti.
I'm totally unaware. I do not know what Mr. Chaudhary
No, you
is
can
submitting.
disregard what
Because,
Mr.
yes,
Chaudhary is saying about the
yes, but
person.
this
Just
is
tell
my
me about the
instruction,
order.
Your Lordship. May I hand up the instruction, what I have
Yes,
received, my
yes,
lord,
yes.
which is contrary to what my
Let
learned
them
friend is
let
submitting.
them say what is the extent
Because
of the
in a
claim
collective
settled.
manner, all the complaints were all lodged before the official liquidator and through a labor union, Your Lordship. Now he's coming up solitary. He's coming up and he is asking for the payment of the remaining balance. And if this is so, then it'll open the floodgate and it'll be very difficult to
representing
tackle.
how many workmen, Mr. Chaudhary?
Not all of them.
What do you mean by all of them? How many?
All workmen. Not,
Mr. Chaudhary, you can't put your claims on a vague basis. You will have to tell the court how many workers you represent, whether you are under some sort of some form of association, some form of at least organized body, some form of an organized body. You can't just one solitary worker coming and saying that, and then the others will be dangling their legs on the fence from the fence and then coming to the court later on.
No,
That
Milord,
that
in
cannot
the
be done.
Earlier application also, Milord, we had come with, Milord, a few workers.
Very well. Mr. Chaudhary, I think the weather is also supporting the official liquidator
Yes.
and the technology as well.
Yes.
So let us see if this works. All right. At least of today. I'm keeping the matter tomorrow. All right.
I'll also, Milord, find out how.
Yes, and please don't come and say one worker or all of them and all of them.
I'll give the exact
Make
figure.
make specific submissions.
Yes, I shall.
Because if I allow this for one worker, then I
I'm-
cannot deprive the others.
No, I'm praying that your lordship passes orders for all workers.
Yes, very well. And if you say Ambattur factory, then that will have how many workers and all that? You
I'll
please
give
get.
all the figures, Milord. I'll
Yes.
bring all the figures.
Learned counsel opinion for the applicant, prays for further orders pursuant to an order passed by this court on 28th November 2022 in a batch of applications, in a batch of similar applications. Stop. Certain limits were fixed. The court proceeded to fix certain limits for disbursal of claims made by workers. Stop. Counsel appearing for the applicant seeks to, is already a beneficiary, has already received 50% of his claim, which translates to about rupees 60,500. Stop. The applicant's claim was 1.21 lakhs, rupees 1.21 lakhs, close brackets. Close brackets, stop. Next, since the applicant is expected to come back with specific facts and figures, comma, this is tomorrow. This is matter tomorrow.
Item number 9, Marine Company Engineers.
May it please your lordship, this is my application, Milord, for refund of monies lying with the original side registrar, Milord.
Refund?
Yes, Milord, because
You did not pay the original side registrar, then why are you saying refund?
I apologize, Milord. The monies had been put in as by way of security.
You want to withdraw?
Yes, Milord, withdrawal application.
Yes.
Milord, the award was dated 23rd September 2018 by an order dated 14th February 2019 passed by Justice Arindam Sinha.
Wait, hang on, please. Yes. Tell me.
The award was dated 23rd September 2018, Milord. Milord, we had secured the entire amount in the award under an order dated 14th February 2019.
You are the award debtor or holder?
I was the award debtor back then, Milord.
What mean back then?
Milord, thereafter the award has been set aside by.
So you became you were the award debtor, now you're the award holder. What are you saying?
No, Milord. We were the award debtor. By an
Yes.
order dated 14th February 2019. We were directed to put in the entire awarded amount as security for stay of operation of the award. Milord, that order is at page 21 of the application, Milord. Thereafter, Milord, and Milord, the register original side was directed to keep the money in a short-term interest yielding deposit.
Yes.
Pending the outcome of the arbitration petition. Thereafter, Milord, by my lord's order dated 5th April 2023, Milord, that award dated 23rd September 2018 has been set aside.
Yes.
As a result, Milord, this application seeking withdrawal of the monies which had been put in with.
Yes, where is my order of setting aside the award?
Milord, the order starts at page 27, Milord. The operative portion is at page 40.
Where does it start?
Page 27, Milord.
This is the stillborn matter,
My lord.
not the stillborn matter.
No, my lord, no. This is a separate matter, my lord, where we had referred the matter to MSME Facilitation Council and
Very well. So you want to withdraw and how much money did you put in?
31 lakhs 30,000.
Where is that order?
My lord, that order is at page 21 of the application, my lord.
$31 lakh?
31 lakh 3,909.
Where do I get that amount?
My lord, the figure is at page 24, my lord.
Yes. And that has been lying invested since?
My lord, yes, my lord. 18th February 2019, under cover of a letter dated 18th February 2019, the pay orders were submitted before the registrar.
Mr. Banerjee?
There is an appeal preferred, Miller, from the judgment and order, Miller, passed by your lordship on 5th of April 2023.
Yes.
There is an appeal preferred, Miller.
Microphone, please.
I'm sorry, Miller. There is an appeal preferred, which is registered as APO number 84 of 20.
But that's a judgment of 5th April. Today we are in October. What order have we got?
Till today, Miller, there is no Miller stay of operation of Miller's Miller order. But Miller, there is an appeal pending wherein Miller we have also taken out an application for Miller stay of operation of Miller's Miller judgment and order, setting aside Miller the award. Miller, there were Miller two parallel arbitration proceedings. Miller, one at their instance before the MSME Facilitation Council, one at
When did you file the appeal?
Miller, the exact date, Miller.
12th October 2023.
12th?
October 2023.
And I'm thankful to my learned friend. My lord, kindly, my lord.
Our application on 27th September 2023.
That 12th October, maybe my lord, the application, when the appeal was before that, possibly my lord, some. Yes, not.
I will ask them, I will permit them to withdraw. Decision in the opinion.
For this much of it, and then of course subject to what my lord feels.
Yes.
That maybe my lord come back in 2 weeks after my lord reopening or the meantime.
Day after. Yeah. It's a judgment of April. You wait for 6 months and then you prefer the appeal, and that too after this application has been made.
Prefer my lord before.
Very well. You don't even have the dates, Mr. Banerjee, no. Maximum tomorrow or day after, that's all.
By that time, my lord, we will not be able, my lord, to move the appeal or my lord get my lord to move.
You should have moved it all this while.
No doubt of that.
This application cannot be a trigger for you to move the appeal. Certainly not. Tomorrow or day after. Get your instructions. I will permit them. I'm telling you, this is what I'm going to do. Yes. Absolutely not. No. They have waited long enough. No. Yes. Learned counsel appearing for the respondent does not have the exact date when the judgment passed by this court was appealed, was challenged. Stop. The judgment is dated 5th April 2023, and it is clear that at least the application for stay of the judgment was filed on 12th October 2023. Stop. Hence, the respondent cannot seek any indulgence from the court in terms of an adjournment. Stop. Next, list this matter tomorrow.
And may I file the affidavit?
The affidavit of service is kept on record.
Tomorrow I can only will supply the dates, will not nothing else.
I will permit them to withdraw. I'm telling you, I would have passed the order today. It is only because you are there's a prayer from your side. That's why I'm putting it tomorrow. I would have passed the order today. Yes. Next. Yes. Yes, we matter to Dakota Salasar Towers.
Item number 5, in the matter of Dunlop India Limited versus E.V. Mathai.
Yes, where is that? Where is the counsel who was appearing for the official liquidator?
She was here.
Yes, call up the official liquidator, please. Call up the official liquidator. I want to talk to him on your phone, video call.
My video. Come in the list.
You don't have a phone with you?
Lordship, I'm just
Call him up, speak to him and tell him that this was a direction of the court. Where is he? I want to know right away.
I'll just call here from here only. So we are waiting. The matter has been called on, sir. My lord is asking me to. Please, link pay.
Yes, ask him why he is not present in court today, please.
Lordship, he is not well. That's what he has.
I don't want the answers from you. Mr. Mojumdar and Mr. Chaudhary, you can put him on speaker mode and let them hear what he has to say.
Okay. Just a minute. Let me call him up.
Mr. Laha, you can also join the party.
Hello, sir. You are on the speaker mode, and we are in the court. Matter has been called on, and my lord has been pleased to ask that why you are not appearing before the court, because today there was a direction for personal appearance. I don't know what is happening. Video call I can do. Let me see. Lordship, yes, you are there. The matter has been called on. Lordship, he is on video call. So,
Mr. Mojumdar, just take the phone from her. And I don't want to turn this courtroom into a circus, actually. So please, all of you go out of the court and come back. I'm waiting. Just ask him why he's not here. I don't want this amusement in court. Ask him why he's not present and tell him that I will actually send the police to escort him to court. Please tell him that.
Item number 10 to 15 in the goods of Honorable Chamria.
Nate, please, your lordship. These are matters. Yesterday, your lordship was pleased to pass an order in a connected contempt application. We are in a position to move GA3, which your lordship was pleased to keep on 17th of November. If it suits your or commensurate to your lordship's list, your lordship can keep these matters on 17th of November.
What are these matters, Mr. Banerjee?
GA3 is the matter where we had sought for deposit of the amounts which the Neeraj Khanna has got from selling the properties which are in Mussoorie.
Very well. Yes, list these matters on 17th November.
17th
Why
November?
17th?
Because GA3 has already been kept on 17th of November.
What is GA3?
GA3 is our application for receiver as well as asking the Neeraj
Very
Khanna
well.
to deposit money.
Since GA3, which is an application filed by the petitioner for appointment of receiver, has been kept on 17th November 2023, list all these matters on the same day. Stop. Next. 17th November, Mr. Medora? Yes.
Yes, all these connected matters would appear, but all these connected matters would appear together. I also have an application for appointment of receiver.
Very well. Yes, everything. 10 to 15. Yes. Call on the passed over matter, please.
Passed over matter, item number 5.
Yes.
He's in his residence. He says that he has a fever.
Microphone, please, Mr. Mojumdar.
He is in his residence. He says that he has a fever and he can present himself tomorrow in court.
Very well. The official liquidator, despite a direction passed by the court for his personal appearance, chooses to play truant and remain locked up in his house, possibly to avoid the strictures which the court was proposing to pass against the official liquidator. Stop. Next. Learned counsel appearing for the official liquidator is equally flippant about the matter and gives the excuse of the official liquidator being unwell, with the expectation that the court will accept the excuse as a matter of course. Stop. Next. The court has heard complaints about the conduct of the official liquidator in another matter, and the official liquidator is in any event answerable for the same, which would be a part and parcel of the larger issue of complete and unexplained delay on the part of the official liquidator to sell out the assets, to sell the assets of the company in liquidation. Stop. Next, list this matter tomorrow. The official liquidator will be in court from 2 p.m. onwards. Stop. Yes, next.
Page 16. Item number 16, Jaspal Singh Chandu.
This is an execution application in which I was opposing. Shotaro Banerjee was appearing on.
You're taking the maintainability point.
Lordship, we were taking the maintainability point also.
Very well. Mr. Court, tell me when you want to come back in November.
Whenever your Lordship, whenever your Lordship.
Dekhiye, you were not here yesterday.
Lordship,
My lord,
you were not there.
List this matter. Learned counsel was arguing the point of maintainability will continue with his arguments on, give me a date in November, please.
Lordship, whenever convenient, your Lordship.
On 16th or 23rd?
16th.
On 16th November 2023. Stop, list this matter on that date.
my lord, I am for the decree holder.
Next.
Seventeen, Ravi Sani, 17 and 18, Ravi Sani.
One application I'm opposing and one
Make up your mind, Mr. Dutt, which side you want to be on.
and that's what I'm trying to make out, Millard. The application which is being heard, Millard, I'm opposing, so I better be on this side.
You're still undecided.
No, Millard. I'm opposing this application, Millard. This is an application which has been taken.
Yes, yes. I remember Ms. Banerjee usually standing on that side on the previous occasions.
And I have my prayer in that execution application for a direction upon them to file their affidavit of assets, because there is already a subsisting one.
Last order, the later.
Order.
Order 21, Rule 41. Learned counsel who was appearing for the microphone, please.
I'm for the judgment letter, Lordship.
Yes.
My senior is coming, Lordship. Honorable Lordship.
Mr. Dutt, why don't you give me tell me what you have to say? There's no point in harassing her. Yes. Yes. Yes.
Millard, here is a decree, Millard, which Millard was passed by consent of the parties, and it would become a decree of court. It was drawn up. The decree basically provided scheme of partition where Millard, both sons Millard have parted their ways along with the business. Now, since previously it was a joint business, Millard, then obviously there were cross guarantees covering the other businesses, which both of them were at that point of time jointly. So the parties decided to part in this manner that they will separate the businesses. Whatever rights and liabilities that they have, Millard, the party who is leaving that business, Millard, would be taken over by the liability of the party who is actually getting that business under the scheme, and vice versa. So far as my clients are concerned, Millard, they have discharged all their obligations under the decree. So far as my learned friends clients are concerned, they have partially discharged. The only obligation that remains to be performed by them, Millard, is to have my name discharged from the list of guarantors in respect of the business which he has got under his control by virtue of the partition. So, Millard, we took out an application for execution. In that execution application, there was an order passed directing them to, Millard, disclose their affidavit of assets. Thereafter, Millard, they came up and filed an application which they say is that there is a arbitration agreement in the terms of settlement. And therefore, if the dispute has arisen, it has to go before the arbitrator, and it cannot be adjudicated in the executing court. Now, my Lord, I have 3 points to argue so far as the maintainability of this application is concerned. My first point is, a decree is a final adjudication of all the rights and obligations of the parties. Once it's drawn up, there cannot be any further dispute regarding what has already been finally adjudicated by a court unless somebody prefers an appeal from that. So there is no dispute, or no dispute can be raised on whatever has been agreed upon or whatever has not received the seal of court. That has achieved finality, it's no more arbitrable. That would be my first. Second objection is, Millard, the disputes which my learned friends are now trying to raise by way of this application, Millard, are disputes subsequent to the passing of the decree in performance of the decree. If it is a dispute arising out of performance of the decree, Millard, then in my respectful submission, and I'll try and argue that it is not an arbitrable dispute. The reason why I say so, Millard, starting from section 47, Order 23, as well as Millard, Order 21, Rule 58, subject to correction. They all say that all questions.
Why don't you take your seat? You don't have to worry. Take your seat. Yes.
All questions, Millard, which arise out of discharge and satisfaction of a decree cannot be adjudicated by way of a separate suit. It has to go before the executing court. Because, Millard, a party who has just completed a trial and a successful, Millard, cannot be asked to take the rigors of another suit. So, Millard, your Lordship will find under Order 23, Rule 4 also, Millard, in the event there is a dispute regarding the terms of settlement, it has to go before the executing court and no other. So, drawing analogy, Millard, from that logic, that if a suit does not lie, Millard, then an arbitration would also not lie to reopen issues already settled by the decree. Those are the two major points, Millard, which I'm going to argue regarding maintainability. I have not used an affidavit because I'm arguing the question of maintainability. And so far as the third point on merits.
You want to question the maintainability of what?
Maintainability of my learned friend. I'm treating my learned friend's application
for dismissal of the execution.
For dismissal of the execution in the nature of an application under Section 8 of the Arbitration Act.
Because Ms. Banerjee said that there's an arbitration clause.
There is.
Yes.
There is an arbitration agreement. But that cannot take into account, my lord. But that arbitration agreement, the arbitrator cannot decide what the High Court has already decided. My lord, it might come back to your lordship, my lord, this one of the issues, this whether an arbitrator has jurisdiction to decide what the court has already decided, fell for consideration saw pipes.
Yes.
Where, my lord, this issue arose whether if section 11, under section 11, the court has held that there is no limitation involved or there is a live dispute, the arbitrator cannot revisit that point under section 16. I'm trying to draw the same analogy. I'm trying to argue. Plus, I'm trying to take support of the fact that the Civil Procedure Code itself says that you can't go before any other. You can't take the judgment debtor or decree holder to any other forum to fight another litigation. That has to be sorted out in a summary manner before the executing. And this is the code which will have to adjudicate upon whether my learned friends are right in saying that if they can't, my lord, discharge this obligation of paying the bank guarantee, what would be the consequences? There's nothing, no dispute involved. They say that I have this obligation, I can't do it. So what steps I can take under Order 21 is what the court will have to decide, but this can't go to arbitration. Those are principally my arguments.
Very well. Mr. Dutt, I'm putting this matter in November. Yes.
So far as that obligation is concerned, to file an affidavit of asset, at least let them file it in court. I'm not seeking an examination right now.
Very well. Learned counsel who was arguing seeking dismissal of the execution case and was arguing and had argued the matter on the last occasion, is not present in court today. Stop. List this matter on. Give me a date. You tell me a date. Microphone.
Lordship, after vacation, Lordship.
Give me a date. Yes.
17 November.
List this matter on 16th or 23rd, Mr. Dutt.
Any day, Miller, whether
List this matter on 16th November 2023. Stop. The court will consider the plea taken on behalf of the decree holder. You're the decree holder. Yes, the decree holder for a direction on the judgment debtor to file his affidavit of assets. Now, the judgment debtor will file his affidavit of assets before the returnable date. Stop. This will be without prejudice to the argument forwarded by the judgment debtor. Stop.
Deeply
19 Ramnath Jhunjhunwala.
My lord, in this matter, I am the receiver. I am the receiver. In the previous day, I have submitted my report.
No one appears for either of the parties. Leaving the learned receiver to leaving the learned receiver in the lurch. LURCH. Stop. List this matter on 23rd November, on 30th November 2023. Next.
Great.
Item number 20, Rajasthan Fertilizers and Chemical Corporation.
My lord, this is my execution petition. My lord, my chapter 13A application was allowed and my lord, a decree of eviction was passed. My lord, in my suit for eviction and mean profit. My lord, regarding...
Where is your other side?
My lord, this is my lord, less than 2 years, my lord. My lord, that is why, my lord, we have not served, my lord, notice, my lord, to the other side.
Yes. So what is it that you want now?
My lord, I am, my lord, praying for, my lord, prayer, my lord, D-I-N-J.
I can't hear you.
My lord, the prayer D-I-N-J of the tabular statement, my lord. My lord, because, my lord, the tenant who is the judgment debtor, They are enjoying my property, which is at 19 RN Mukherjee Road, and my lord, using it for commercial purpose. My lord, prayer D, my lord.
No, that is warrant for delivery of possession, can't be given now. I is what?
My lord, I is an order of injunction restraining the judgment debtor from using or utilizing the said premises for its commercial purposes or for any purposes whatsoever.
Decree is dated?
My lord, 14 July 2023, and my lord, it has been corrected by an order of 29th August 2023.
Very well. You come back in November, please.
My lord, also kindly considers my prayer, my lord, J, my lord. My lord, an
No,
order.
come back in November and show me the provision of law that you are entitled to move ex parte if
Yes,
it's
my
less
lord.
than 2 years.
Yes, my lord. My lord, order 21. My lord, rule 22 CPC. My lord, order 21, rule 22. My lord,
Yes.
if I may place, where an application for execution is made more than 2 years after the date of the decree, or against the legal representative of a party to the decree, or where an application is made for execution of a decree filed under the provisions of section 44A, or
No,
against
this is more than 2 years. You're saying less than 2 years.
provided, the first proviso, my lord.
Yes.
Provided that no such notice shall be necessary in consequence of more than 2 years having elapsed between the date of the decree and the application for execution, if the application is made within 2 years from the date of the last order against the party against whom execution is applied for, made on any previous application for execution or in consequence of the application being made against the legal representative. And my lord, thereafter, my lord, sub-regulation 2, if I may, nothing in the foregoing sub-rule shall be deemed to preclude the court from issuing any process in execution of a decree without issuing the notice thereby prescribed, if for reasons to be recorded, it considers that the issue of such notice would cause unreasonable
Yes.
delay.
So the satisfaction has to be recorded.
My lord.
That any further delay will defeat the ends of justice.
My
That satisfaction must be returned by the court.
My lord.
That finding must be returned by the court.
My lord.
Yes. So this is a decree of
Eviction, my lord.
yes, 29th August to be more precise. So you it's not that you will lose something valuable if you come back in November.
My lord, the difficulty is, my lord, they are, my lord, using my premises as, my lord, a commercial space, my lord.
And they were doing that since when?
My lord, since 2018 September.
18 September.
My lord.
Very well. So you can wait for 1 more month. Yes. Although learned counsel appearing for the award decree holder seeks orders in the nature of an injunction restraining the judgment debtor from dealing with or disposing of the premises and the movable properties lying therein, comma. The decree is admittedly of 14/7/2023 as corrected on 29/8/2023. Stop. The plea of the judgment debtor using the premises as a commercial, what did you say?
Space, my lord.
As a commercial space also has also continued since 2018. Stop. Next, hence, comma, this court is not inclined to pass any orders ex parte before giving the judgment debtor before the matter is ex parte nakerada. Hence, comma, the decree holder will not suffer irreparable prejudice, at least under the at least under order 21, rule 22, within brackets 2 of the CPC, if the matter is taken up in November 2023, stop. List this matter on, give me a date, please.
Any day, my lord, subject to my lord's kind convenience.
23rd November, 30th November 2023, stop the, did you communicate the last order? No. You want to move ex parte?
My lord.
I will not give you that kind of restraint ex parte, I'm telling you. Yes, list this matter on 30th November 2023.
Right, my lord. Obliged.
Industrial Growth Enterprise.
This is my execution application, Lordship. I appear for the award holders, Lordship. There was a direction on the judgment debtor, my lord, to file an affidavit of compliance, my lord, with respect to the order passed for a security in terms of the order dated 15th of May, 2023. My lord, they filed their affidavit of compliance, my lord. They're only perhaps, my lord, the commission component, my lord, is to be calculated at the rate of 1% on the interest, at the rate of 1% on the principal, my lord, and 2.2 on the
Commission of the
registrar, my lord.
Yes.
So, my lord, if your lordship,
Chapter 56.
Chapter 35, my lord.
Chapter 35.
35.
Rule 56.
Rule 56, my lord.
Yes.
My lord, if your lordship kindly takes, my lord, the affidavit of compliance, my lord.
Yes.
Lordship has them.
Yes.
Lordship, paragraph 3, my lord. That in terms of the direction passed by His Lordship, the Honorable Justice Shekhar B. Saraf on 15th of May 2023, which was further extended by His Lordship, the Honorable Justice Ravi Kapoor on 27th August 2023, and again on the 31st of August 2023, in GA number so-and-so, NBCC India Limited has deposited half of the awarded sum with interest in both demand draft as cash security with the registrar original side on the 1st of August 2023 being rupees 70,68,077 rupees calculated as
Yes,
on
yes. Yeah, yes.
the remaining half of the said awarded sum in bank guarantee on such
Together
and such.
with 71,000 being the 10% registrar's commission.
Yes, my lord. My lord, I'm saying, my lord, this couldn't have been, my lord. This
Yes,
is
yes. What
perhaps
do you have to
the-
say, Mr. Borman?
My lord, as per the direction of the, my lord,
Microphone, please.
as per the direction of the Office of the Learned Registrar, my lord, we have deposited the sum of money.
No, it has to be 1%. That's the original side rules. Chapter 35, Rule 56.
My lord, if anything is found to be deficient, my lord, we're ready to pay, my lord.
Not deficit. You have to pay less. It can't be 10%. It has to be 1%. You have said 10%, and there's something wrong with the calculation anyway.
My lord, we are told, my lord, maybe we have not calculated in that way, my lord. We are told by the office that this sum of money is to be paid, my lord. Accordingly, we have paid, my lord. If any amount is to be, my lord, returnable, you can file an appropriate application with the registrar.
Yes, the affidavit of compliance filed by the respondent judgment debtor states that the judgment debtor deposited cash security of rupees 70,68,777 as calculated as on 30/6/2023, and the remaining balance of the same amount in the form of a bank guarantee on 4/9/2023. Stop. The paragraph, however, it is however stated in the said paragraph, in paragraph 3, that the judgment debtor has deposited rupees 71,131 being 10% of the registrar's commission. No, has however paid, it is however stated in paragraph 3 that the judgment debtor has paid a sum of rupees 71,84,216 being 10% of the registrar's commission. Stop. Next. Since chapter 35, rule 56, just check please.
No.
Of the original side rules. Chapter 36. Yes, since chapter 36, rule 56 of the original side rules. Yes, since chapter 36, rule 74, entry 56 of the original side rules says provides for otherwise, comma. This order shall be this as well as the affidavit of compliance as well as this order shall be communicated to the registrar, comma, original side by 4:30 p.m. today. Stop. The registrar will file a report by tomorrow. Stop. List this matter tomorrow. Stop. The parties will act as the parties will implement the order as dictated in court. Very well. We'll communicate this order on the registrar by 10:30 a.m. tomorrow. Stop. List this matter on 19th October 2023. The registrar shall file a report to that
Instead of
effect.
19 area.
What any other day? You want to come in the
After
vacation bench?
After vacation.
No, no. What are you saying? Yes,
I'll be out of state.
to communicate this order on the registrar change kore daw. By 7 p.m. today, the registrar shall file a report by tomorrow. Stop. List this matter tomorrow.
Grateful, Lordship.
Your
Next.
leadership, before your leadership calls on the next matter, item number 19, your leadership of your leadership's today's.
What is it? You're not supposed to mention now. What are you saying?
The leadership, I was on my legs. I missed the matter when it was called on. I'm extremely sorry.
Key which matter does it?
Item number 19, it has been kept on 30th November, your leadership.
Yes, November. I will not take it up in the next 2 days. Next, call on next matter, please.
Item number 22, Rajpath Contractors.
She had passed a judgment on 26th of September, directing them to make a
At
payment.
Kaj. Rikichi. I will put it on the reopening day. What is the problem? No. Reopening day. কবে আছে এটা? কবে করেছে এটা? 30th November. ওটা 16th November করে। Can't understand what you're saying. No, you're not required to be present. 16th November. Yes. No further. Yes.
Lordship passed an judgment on 26th of September, directing the respondent's judgment debtor to make payment of rupees 20 lakhs odd within 3 weeks.
16th বদলে কাজ করো তো 23rd November করে। 23rd November. Yes.
Lordship, the judgment, Lordship, kindly have a look. 26th September 2023. Lordship
Yes.
directed last page, 4th page. Lordship directed the first paragraph.
What is it that you want?
The payment to be made within 3 weeks from the date of the order. The 3 weeks lapsed today, Lordship. No payment has come. We have intimated to the parties.
This is for in the matter of stay.
Execution, yes, state.
No, execution case.
Execution, or everything, 34, 36, 7 says over, Lordship. The Lordship recollects that error in calculation.
Yes.
And
Yes,
Lordship,
where is the direction?
yes, 4th page. First sentence, once the fundamental calculation went wrong, the other natural becomes vulnerable. This court hence is of the view that the award debtor should be directed to pay the balance amount of 20 lakhs to the award holder within 3 weeks from today.
This is of 26th September.
Yes.
No, the last page is the decision of the Supreme Court in Hydra Consulting and all.
First sentence of the last page.
Yes.
Once the fundamental calculation went wrong, the
Yes.
3 weeks from today, Lordship. That 3 weeks ended today, Lordship. No payment has come
Yes.
forth, Lordship.
Kindly gives us some more time.
Microphone, please.
Kindly gives us some more time, Your Lordship. We have already intimated.
Lordship, for this
What do
reason.
you mean you have to file an application, Mr. Mondol? You can't, on the submission made by petitioner, you can't ask for that prayer. What do you mean by
Today it is going to expire today. Your Lordship.
today?
Lordship,
If the date of order is excluded, I would say till tomorrow, I would say.
Till tomorrow. So are you ready to make the payment tomorrow?
No.
Then why you superfluous submission? Then why are you saying this?
I would have prayed for extension of time.
You would have prayed where and when?
As and when
Vacation
the-
bench.
As and when the matter comes. So today I'm praying this.
May I see this, Lordship?
Yes.
There is a prayer in my application that Reserve Bank of India be directed to make payment. Lordship, if that is followed, the payment will come in automatically, Lordship. In every execution application, Lordship, these prayers are there, Lordship. Lordship, will kindly have a look at prayer B, Lordship. The Reserve Bank of India be directed
Yes,
to
learned counsel appearing for the award holder submits that the award debtor is in default of the direction passed in the order dated 26 September 2023, wherein the award debtor was directed to pay the balance amount of rupees 20,67,502.00 to the award holder within 3 weeks from the date of the order. Stop. The 3 weeks expires today, and the award holder and the award debtor has not taken any steps for compliance with this direction, with the above direction. Stop. Next. The advocate on record of the award debtor submits a praise for more time, a praise for extension of time to comply with the order. Stop. Next. Such random prayer cannot be acceded to, particularly since the award debtor has taken no pains to file an application or otherwise. Stop. The prayer for extension is made in response to the submissions made on behalf of the award holder. Stop. Next. List this matter on 19th October 2023. Stop. It is expected that the award debtor will take steps to comply with the direction within the returnable date. Mr. Dutt, which matter are you waiting for?
Next matter.
Next matter, Lord.
Report to Dakota.
23.
I'll be very
Timothy
short.
Debarati Sen.
It's that matter, my lord, where I was insisting upon some part payments being made. I was insisting upon certain part payments being made because we were not agreeable to wait till 24.
Yes.
They have given us a letter where they agree to pay 3 lakhs by 20th of November. Let them pay 3 lakhs and Lordship keeps the matter thereafter, my lord. We'll come back.
By 20th November.
That's the same.
Yes, learned counsel appearing for the award holder. What is it? Decree holder? Decree holder.
Award holder.
Award holder.
Becomes a decree.
Places a letter.
My lord, don't mention that letter, and I tell you, Lordship, why? Because this letter is worded in such a fashion, my lord, your Lordship will find that my learned friend probably is trying to create an agreement after that as if the payment is linked with the sale. His obligation is to pay. That's what I'm saying. Let him pay without prejudice to that.
Yes, relies on the what undertaking? Undertaking
He said to pay 3 lakhs. my lord.
relies on the undertaking given by the award debtor that the award debtor will pay 3 lakhs by 20th November 2023. Stop. Next, list this matter on, give me a date, please.
Date the moment, 22nd, 21st, 22nd, 23rd.
List this matter on 23rd November 2023. Stop. The award debtor shall make payment of this amount within the returnable date and as within the returnable date.